Yes.
Got it. So I was reading para 32 on page 109.
Yes.
Second last line. At the same time, it is the case of some of the petitioners that they are permanent residents of state of Gujarat and having passed 11th and 12th standard from the schools situated in state of Gujarat, they are not fitting into eligibility criteria only on the ground that they have studied 10th standard from the schools situated outside state of Gujarat. We deem it appropriate that the said matter is required to be considered by the respondents. Now, Millards, with these directions, my lords may kindly have a look at page 113.
Yes.
113. On 25th of June 2018,
Yes.
a proviso was inserted. If I can just read two. In the Gujarat Professional Medical Educational Courses, regulation of so and so, in Rule 4, in Sub Rule 3, before the existing proviso, the following proviso shall be inserted, namely, provided that for the purpose of admission for the academic year 2018-19 only, the candidates who have studied and passed 10th standard from the school located outside the state of Gujarat shall also be eligible. Similarly, Milots, for the next year, on page 116,
Yes.
dated 15th June 2019, again they dated Milots at the last line for the year 2019-20. Now the question, Milots, the rule works retrospectively, Milots, for the past 3 years. So the 10th standard, only 10th standard people have been left out, students have been left out. Now this year, the question is, can they have to extend the same benefit for this year only? Next year, if someone comes before the court with a similar relief, then yes, state is right in not extending the benefit by way of this notification in exercise of powers under subsection 1 of section 20. Now the rule cannot work for 11th, 12th, 11th and then stop at 10th. If they want to make the rule operative and working, Milots, there is no question of challenge to the rule, but it has to operate for 3 years. You have to give this relaxation for the last year, that last time for this year. Next year, if I come before my lords or anyone comes before my lords with the same rule on hand, yes, state is legitimate in saying that no, now we cannot do it because 10th standard you have not cleared in that year. So therefore, Milots, the benefit has to be extended as far as this year is concerned only. Lastly, they cannot stop at 11th and 12th and say that no, now you cannot get this benefit and this is sympathy jurisdiction. Milots, with all due respect, Milots, there was no question of sympathy. This is my right. I am a bright student. I am 96% plus student. I took admission in 9th and 10th. I could not have come out of 10th midway. They could, if they would have amended the rule prior to March of that year. It was a separate thing. Then yes, today the state can legitimately argue.
All right. Yes, Level Government, Peter.
So far as the state is concerned, Milord, in the exercise of the powers under section 20, these rules have been framed.
Nobody is challenging your powers. There is no challenge to your powers.
Correct. There's no challenge to the past. There's no challenge to the rules. What, Milord, by virtue of the proviso added for the year 1819 and 1920, a concession has been given for that particular year rule, for that particular year alone. My submission is there is no enforceable right, and I can satisfy the Honorable Court through catena of judgments. The prayer which my learned friend is seeking is contrary to statutory rules, which per se, as they stand, cannot be granted. What effectively he is seeking is that the rules be modified for the present year also. That, my lord, in my submission, may not be granted by way of a mandatory direction. It's a matter of policy for the state to take. And the state has taken a decision, which has stated by way of an affidavit, that this year we are not extending the benefit of this rule any further.
Right. Let us test the decision of the state.
Please, my
on the applicability of the rules, the two notifications issued, and otherwise also reasonableness. Right?
Please,
now, if a candidate has studied class 10th, supposing in the year 2016-17 academic year.
Please, my lords.
Right? Now, 11th and 12th, there is no dispute. We are saying that all candidates have to undergo 11th and 12th from the state of Gujarat.
Please, my lords.
This only relates to passing class 10th, whether from Gujarat or outside Gujarat.
Please, my lords.
Now, generally in board classes, once you come to class 9, then it is you want to continue in the same school. class 9th and 10th. 2-year course, kind of. Although you can get admission from 9th to 10th to another school also. You can go to a different state also. You can go to a different city also in another school. But generally, you prefer to keep your children in the same school. Correct? Now, supposing somebody who has studied class 10th in the year 2016-17 and today in 2020 NEET examinations has a good score and is otherwise a domicile of state of Gujarat, has studied class 11th and 12th in the state of Gujarat, would or would not he or she be entitled to the benefit of the 85% of the state quota?
No, my lord.
Why? Why?
Not entitled, because the rules come into play for the year in the year
How can you make these
2017.
rules retrospectively applicable? Somebody who has studied earlier, you say, no. Because you've studied earlier, you are out.
My lord, this argument of retrospectivity has already been tested, and the vires of these rules has been upheld in 3 consecutive
So
judgments of the Honorable
that
Court.
student doesn't get domicile or benefit of the state quota of any state.
No, my lord, he would get in the All India quota, he would get it in
All
Rajasthan.
India quota is only 15%. Here, 85% state quota you are giving to your domicile and your
Lord,
candidate.
the student had another option. He could easily have taken admission in the Rajasthan quota. The state is responsible, my lord, for giving admission to its own.
Wait. It is very unreasonable. The parents are residents of Gujarat state or any particular state where they have lived all their life. They are in surveys, they are doing business, doing whatever. If they send their children to study outside for a couple of years, do they lose their right of domicile? And this rule you bring in 2018.
We are not non-suiting them on the ground of domicile.
This rule has come in the academic year 2017-18.
That's right. That's right.
And you apply it to students who have already passed their class 10th earlier.
My lord, this is being applied. So, my lord, for the academic year 17-18.
How do you debar somebody who has studied 11th, 12th year, but class 10th in the previous academic year earlier? What is the justification? How do you say that this is reasonable?
My lord, when admission rules were notified, the requirement was that you were required to undergo standard 10 from the state schools. With this requirement of iris.
Therefore, that's what I'm saying. From that year onwards, you apply this rule.
My lord, what my learned friend is seeking essentially is a modification of statutory rules, a concession which cannot be granted. A concession granted in the year 1819, 1920 cannot be made an obligation on the state.
What your friend is saying, you answer our question. How do you justify these rules to students who have passed out class 10th in the previous year but fulfill all other requirements as per the rules, and today you bring in a new condition and you debar these students?
Milord, it is not a condition which has come today.
How reasonable is that?
Milord, it is not a condition which has come today. This condition is existence since June 2017. Milord, therefore, the student had the option.
First, you listen to our question. My question is, a candidate who has passed class 10th in 2016-17 academic year, right?
Milord,
when class 10th was not a requirement.
Milord, 16-17 will not take admission in 2020 in medical.
They'll definitely take admission. So many will take admission.
Milord, no, Milord, admission is to be taken, Milord, of the last of this year's 12th standard. You need to clear this year's.
Today's times, students sit for 2 years, 3 years at home preparing for NEET. They drop examinations, they drop their own career, they don't join graduation because they want to go into NEET. 1 year, 2 year is a standard this thing. 60% of the students selected in NEET must have dropped 1 year or 2 years. Understand this?
Milord,
how the logistics are working today, how the dynamics of students is working, the kind of competition these students are facing, how they study, how much hard work they put in for years together to qualify for NEET. Now, here is the case where 2016-17, a student has passed class 10th from outside the state of Gujarat. Correct?
Milord, this student has not passed 16-17. This student has passed in 2018.
Right. We are discussing, testing your rule.
Correct.
The version of that rule.
Where is the challenge to the vires of the rule?
We are not saying that. Since they have also not challenged the vires of your rules.
They are not challenging the rules.
Whatever the vires challenge was there has already been upheld.
Correct.
If you're wrong, we are not commenting on that. It has been upheld.
Correct.
You have issued 2 notifications in 18-19 and 1920.
Please, my lords.
Now, this year you have taken a decision that you will not issue any such relaxation.
That's
correct?
right. That's right.
Therefore, we are testing the decision of the state.
Look, the decision of the state is founded on justifiable reasons to
That's what we are
decide.
trying to test. We are asking
When-
you questions to
correct.
justify your stand.
Right.
In
Milord, when
1617, a candidate has passed class 10th outside state of Gujarat,
correct.
when there was no requirement of passing class 10th in the state of Gujarat.
Right.
Now, 1718, 1819, the candidate studies 11th and 12th from the state of Gujarat. All right. Now, in the 19 NEET, the candidate does not qualify. In 20 NEET, the candidate gets a very good score. Now, which state domicile or which state under the rules 85% quota would that candidate be entitled to?
Milord, therefore,
That's
this
the question.
candidate, yes, Milord, this candidate who has undertaken Milord Standard 12, 16, 17, Milord, from any university outside the state of Gujarat had two options. Milord, when we make
What
choices,
about the options which were there earlier? Now, once you frame a rule, you have to take care of these students also.
Milord, we
How can you
take
just
care, Milord, the
discount
state
them?
is responsible for taking care of, it's a question of balancing interest. The largest populace we take care of.
Correct.
To the last single option, exception, which may be carved out for any hardship, Milord, rules cannot be modified. My submission is, Milord, a student who makes a conscious choice, chooses to study outside the state for 16, 17, has the option of studying for the 11th and 12th outside. For reasons any and many, he may have chosen to come back to the state. In which case, Milord, he is required to face all the options which
Now,
are then. All
tested on
academic
the-
matters are a matter of choice.
Not just one. Now, tested on the other side. Earlier, there was no requirement of domicile. Now, domicile has also come into play.
Correct.
Correct?
Validity again upheld. Domicile was also challenged. Domicile was challenged. Hardship was the argument. There is no enforceable right in a student to say, I will study in my state alone. There is no enforceable right. When you make choices, when you take decisions, these are decisions coupled with an element of chance. Every decision taken is coupled with an element of chance. The reason he took an admission in quota for better prospects perhaps may have worked, may not have worked. The state cannot be getting into the mind of every child to examine the reasons and the objects for which, Milord, such decisions are taken. Every step taken is always for a betterment. Be that as it may, today, Milord, when the state is taking a policy decision, Milord, in my submission, we are bound by statute. What he's essentially saying.
Exactly what we are trying to. We are not conversing, Mr. Desai would be conversing. What we are trying to ask you, when you come up with a rule, you apply it from that date onwards.
Right.
You are ousting students from getting their 85% quota in the state, which they fulfill all conditions, including domicile 11th, 12th, but for something which they have already done and acted upon. You say, no, you are out. How far is that justifiable?
Yes. Milord, my lords, be pleased to see, while examining the vires, one argument, the Milord, on behalf of the Advocate General, submitted that last year itself, 400 students from, Milord, outside the state had taken admission. These are essentially the students who ultimately do not land up staying back in the state. They take the advantage, the benefits of the infrastructure, of the academic teachings which is being made available by the state. But the state does not manage to receive the benefits of these students who ultimately pass out. And all these numerical data, all the factual scenario, all of it was considered. Having considered it, the rules were upheld. However, the Honorable Court said, you may consider for this particular year if you deem appropriate. That considered for 18, 19.
Why did you consider for 2 years? Why?
Milord, it was considered for 18, 19.
Why?
And thereafter it was considered for
Tell us
19, 20.
Tell us why. What has changed today that you are not considering it this year and you considered it for 2
Milord,
years?
the reason why it is not considered it, Milord, the reason for the third year.
So, no. What is Why did you consider it for 1819 and 1920 and not?
Because a student, Milord, a student who has already completed the 10th, Milord, for that student, we are not able to do much. But here is a student who took admission
No,
in
but you say
April.
that the rule has.
It was always open.
That.
Milord, the
One
rule
minute
was
per day,
notified.
and you do whatever you feel is proper. You have done it. Then why do you relax it? Why don't
A
you-
moment. Milord, a student, the rules were amended in June 2017. This student has taken admission in April. It is always open to the student to opt for the state
We
admission.
are not talking about this particular matter. We are asking you why did you relax that for 2 years?
Considering that those students who may have already studied out may
So
not be
you
not
realize that there was
requirements.
some error in your rule and therefore you are doing it. You are taking hardship as a consideration.
Milord, it was only
You are
considered as
reasonable.
a
You are being fair.
Milord, so far as the present petitioner is concerned,
No, no,
my
we are-
lord, at least you see this option was open to him. June, we amended the rules. A student who had taken admission in April may very well come back to the state. In June, he was aware that with 10th standard in quota, he would not be able to come back to state of Gujarat. It was always open for him to take admission in June. He chose to continue, my lord, in quota.
Then supposing you had brought out another rule in October saying that no, you were allowed to,
Milord, can that be?
and was not required. They could have gone back to this. How
Milord,
many times would they take admission in
can that be the
academic year?
consideration of the honorable court? Would
Once
these
you take
factors weigh with the
a-
honorable court?
Once you bring out a rule, apply it prospectively and don't oust students who have already acted upon their previous existing rule and they are not violating any part of your rule.
Milord, my submission is that so far as 2017 rules are concerned, those who would have acted would have been in 2016. Those who would have acted would have been in 2015. Whereas in the facts of this
is what
case,
we've been saying that
yes,
if you are
but in
taking
the
into
facts
consideration
of
all
this
those
case,
aspects, why not this?
yes, because in the facts of this case, this student has taken admission in April. He very well could have changed his admission in June.
Ms. Shah, just come to page 111.
In June, my lord, he had the option. He had the knowledge and option.
How many times the Gazis are going to pay the fees? Do you realize what is the fees of and how much is the cost of staying in a hostel and paying the entire year's fees? Nobody charges fees for months. And then getting a fresh admission in another school in midterm is so difficult.
My lord, there
How
may
is
be
the state
any
going
and
to
many such there may be any and many such hardships.
All right, you have no answer.
It's not a
to that.
matter of policy.
Just because you are mighty and you are powerful, you can make any kind of rule and
No,
try
no,
to
it's not
justify
about
it.
mighty, it's
I
a
don't
question.
agree to that.
You know, the question
The
is,
state is not justified
the
anyway.
state is not inclined to open floodgates to those students who have studied outside. The virus is not a matter of
Anyway,
challenge
you
today.
take a decision and implement it from the next year. Who stops you from doing that? You have done it and successfully you are doing it. Nobody is stopping you. Maybe a
You know,
state.
the
few
virus
categories
today
of
is
here and there
upheld these
who
rules.
who are in this kind of a situation would come. Not all. Yes.
Ms. Shah, come to page 111.
Please, my lords.
We are referring to para 34.
Please, my lords.
But you may skip around first part of para 34. The sentence starts like this. It is the case of some
I'll
of
read.
the petitioners.
It is the case
Just a
of some
minute,
of the petitioners that
just a
though they fulfill domicile,
1 minute. It is the case of some of the petitioners that though they fulfill the criteria of domicile and passing requirement of 12th standard from the school situated in Gujarat. So, twin requirements are fulfilled, domicile and 12th standard from the school situated in Gujarat. But they are excluded from the eligibility criteria only on the ground that they have studied 10th standard from the school outside state of Gujarat. Exactly the situation in the present litigation, correct?
please, my lords.
Now, just make us understand the ration, the idea of such observations which we'll read now. In that view of the matter, as object of the rules, is to give benefit to the candidates who are domicile of the state of Gujarat. We just want to understand from you, is this candidate not a resident or a domicile of the state of Gujarat? We direct the respondent state to take decision forthwith on the said issue whether to continue Rule 4.3 subclause II of the regulation so and so in the same form or not, and take appropriate decision accordingly without loss of. Now this gave rise to page 113 and 116, right?
That's right. That's
Now
right.
the object seems to be, the court observes, as object of the rules is to give benefit to the candidates who are domicile of the state of Gujarat. If you hold, if you believe that the domicile of this student is also of Gujarat, then why not give one benefit for this particular year?
My lord, I
That is
have
17, wait a minute, 18, 19,
1920 they have
19,
given.
20, 2021, and
That's
that's the end of it.
That's it.
Then you cannot, nobody can ask for any further extension.
That's it.
my lord, I have
Just
my
one
lord,
minute.
I have threefold arguments.
Yes. Now, where is your affidavit?
No, the affidavit is at page 122.
122. Right. This was the affidavit in reply filed before the learned single judge.
That's right.
Yes.
Yes.
Yes. So, my lord, the stand of the state government is that it was carved by way of an exception, and the vires of the rules has been upheld. This argument of hardship, reasonableness, and the justification and the rationale were placed before the Honorable Division Bench. And not just this judgment, my lord, there is also another judgment rendered by the self same bench, being Special Civil Application number 13877 of 2017. My lord, copy of which was forwarded, my lord. Perhaps it's there, my lord, in the matter.
It's part of the record.
My lord, not by way of an affidavit, but I forwarded it.
Judgment doesn't need to be filed by an affidavit.
Yes.
What is the date of that judgment?
Yes, my lord, the
13877?
judgment is dated 4th of August 2017.
What was the challenge in this judgment?
My lord, the challenge in this judgment was analogous, that here was a student who had happened to study in Daman, which was included, but not from a state affiliated board, not from a Gujarat board. And whilst my lord
And
examined
also the state extended the benefit by the
Yes.
way of notifications.
Yes, the state, my lord, at the Honorable Court noted that, my lord, this argument which is being sought to be leveled or raised, my lord, by the present petitioner is not up to be upheld. My lord, if I may just read few lines, my lord.
Yes.
Paragraph 5.5. The learned government leader thereafter placed reliance on so and so, wherein the division bench of this court held that resident requirement in a state can be definitely
Just one
introduced.
minute. Just a minute.
बुरा लग जाएगा अगर ऐसा बोलेंगे तो.
Yes.
Para 7, my lord. It is revealed
हाँ, पढ़िए.
It is revealed that the petitioner had passed standard 10th and 12th qualifying examination from a CBSE school situated in Daman. The main grievance of the petitioner is that though the petitioners are domicile of the state of Gujarat, merely because the school in which they have studied is situated outside the territorial limits of the state of Gujarat,
Yeah, okay.
because of them, the impugned rules, the admission is denied to them.
उसने वहाँ से यूनियन टेरिटरी से किया.
और 12th भी वहीं से किया.
हाँ.
दोनों किया वहाँ से. In this case, the candidate had done 10th and 12th both from outside Gujarat, right?
Correct, correct.
And you extended that benefit by way of the notification.
No, my lord, no benefit is extended. The
Okay.
Honorable Court upheld the decision not to extend.
All right.
Para, my lord, internal page 28 of the judgment, relying on, my lord, referring to the judgment which was pointed out, Vishaka's judgment and Sheetal Kumar, in the Honorable Court notes para 10 of Vishaka's judgment. Thus, so far as the admission to MBBS, BDS courses are concerned, the law as it stands is settled by the Supreme Court that the state government is given the right to reserve 85% seats based on merit, restricting it only to students who have passed standard 10. In the cases before us, we find that the Gujarat rules, the aforesaid direction given by the Supreme Court has been maintained. Similarly, in the case of Sheetal Kumar, this writ application under 226 of the Constitution, at the instance of the student who has been denied admission to professional courses on the ground of not having studied in a CBSE school located within the state of Gujarat, has prayed for the following reliefs. My lord, there were three judgments, my lord, of the Honorable Division Bench in different fact scenario. One where 10th was done, one where 10th and 12th was done outside, and the Honorable Court in para 33 notes, in our opinion, the classification is thus absolutely valid and does not in any way violate the provisions of Article 14 of the Constitution of India. Such kind of classification has been expressly approved by the Honorable Supreme Court. And para 13, it is revealed that the respondent state
from this sub rule for the academic year 1920.
ये भी आया सर.
ये क्या है?
Provided for the.
हाँ, ये तो हमारे लिए इस तरह के कैंडिडेट 10th वाला आया. और ये पूरा एग्जाम कर दिया था उनके लिए. Yes.
Para 13, my lord, it is revealed that the respondent state wants to give benefit of state quota to all the schools situated in the state of Gujarat, as well as to students who have studied in the state board. Thus, when the student who has studied from school affiliated in the state board and those situated out of the state of Gujarat are given the benefit of state quota seats in medical and paramedical courses, whereas the students who have studied standard 10th and 12th qualifying examination, other than school which are not affiliated with the state board and are situated outside the territorial limits, are denied such benefit. We are of the view that by doing so, the state has not made any discrimination. As alleged by the petitioners, it is required to be noted that the petitioners can get admission in the 15% All India quota, and therefore they cannot insist that they should be accommodated in the state quota only by the respondents. It is submitted, the submission canvassed by the learned advocate, Mr. Shellet, that by providing two different eligibility criteria for admission in professional degree, because in professional, below this requirement was not there. Professional and medical courses, below the Honorable Court notes, below that there is no arbitrariness. The demand for medical is far more. And thereafter, relevant paragraph 16.1. At this stage, it is also required to be noted that the division bench of this court in Vishakha and Sheetal Yashwant Parmar has considered the decision of the Honorable Supreme Court and other decisions. It is further required to be noted that the learned advocate, Mr. Shellet, is not in a position to point out that the aforesaid two decisions rendered by the division of this court are reversed by the Honorable Supreme Court. Thus, when the aforesaid two decisions rendered by the division have attained finality, we are of the view that the present petition is required to be dismissed. And the petitioners are not entitled to claim the benefits. My submission is, below, the rules are a case of delegated legislation. The validity of these rules has been upheld. There is no enforceable
there is no challenge to the rules today.
There is no enforceable right vested in a student to claim admission in a particular school or in schools situated in the Gujarat dehorse the rules.
No, but we are testing the action of the state, whether it is reasonable or fair or unreasonable or unfair. That is what we are testing. We are not testing your rules.
Milord, the
There
rules.
is no challenge to the rules by Mr. Desai or by the appellant.
That's right.
So
Milord,
we are only testing the state action.
Milord, the state action is born out of the statutory rules. In the absence of the
state will
challenge
have
to the
justify
rules,
why it granted that exception in the last 2 years and is not willing to grant that exception in this year, when the
Milord,
situation is more or less the same.
Milord, I am not required to answer the challenge to why the
If
rules.
the state has no answer, then the state can always say that we will not give an answer.
No, Milord, my submission is, Milord,
Yes.
my submission is this wise. My submission is that the rules as they stand today do not permit a student who has studied standard 10 outside the state of Gujarat to get admission. There is no challenge to the rules. In the absence of the challenge to the rules, I am bound by my own rules.
Correct,
The
very
admission
correct.
committee is bound by its rules.
Cannot,
The
you
state is
cannot-
also bound by the rules.
not violate your own rule.
Correct.
But you did respect the observations made by the division bench while upholding your rules for 2 years, 18-19 and 19-20. For this particular year, you are not willing to criticize or honor or respect that observation of that division bench judgment by which your rules were upheld. For 2 years, you did. But this year, you're not willing to do it, right?
Milord, the Honorable Court had made certain observations stating that you may consider.
Correct.
Therefore, it was left to the domain of the state government
Exactly.
to consider. My consideration is not a matter of challenge today. The petitioners.
No, that is what is under challenge. He says that you say that we are not going to exercise this.
The petitioner is seeking applicability of the rules for this year itself and claiming admission for the year 2021. If he were to challenge my decision by holding that your decision not to grant this benefit, the rules would be a subject matter of challenge.
Tell us one more thing. In 2018-19, did you exercise that discretion on a petition being filed or merely on the basis of representations made by candidates, or the state on its own took it up and then granted that relaxation? And again in 1920, whether it was pursuant to further directions being issued or pursuant to the same observations made by the division bench upholding your rules?
Milord, I'm not privy to the decision-making process for 18-19 or 19-20. I'm only aware that, Milord, by way of a notification, the object, the rationale, the reason behind it,
whether that notification had come on its own, or it was under some further direction by the court, or upon representations being made by some candidates.
Milord, today, Milord, I'm aware that, Milord, the court sympathetically and on equitable grounds believes that for this year it ought to be extended. But where is the foundation for, Milord, such extension? He's seeking implementation of the rules as a mandatory right, that these rules should be made applicable to him and him alone by considering standard 10, which
There's no question of any mandatory right or any enforceable right. Mr. Desai's petition and appeal are basically based on a request to the state. That's all. Nothing more than that.
Milord, that request of the state, Milord, so far as the state is concerned,
to act as fairly as it did in the last 2 years.
Milord, the state has already notified these rules. A decision was taken for 18-19. Milord, my submission is concessions and exceptions cannot be claimed as a matter of right. It's in the realm of policy. Having considered the larger effects, it is not about one student. I understand my lord's sympathies with the petitioner, but my lords may also be pleased to examine that so far as the state is concerned, it is considering an entire policy. How many are we going to allow and how many are we going to permit to, my lord, seek these benefits is a concern which the state holds. Apart from individual hardships, which challenge, my lord, has already been negative, and even this honorable court perhaps would have negative, individual hardships are not the case. Much as my sympathies may go with the petitioner, much as I may want to give it as a policy, when as a policy the state is considering, and the state believes that as a policy, we want to put an end. 2 years we gave the benefit, no more and no further. Can this policy be faulted when at the outset, for the very first year, this honorable court had upheld and said, we are only suggesting you may consider, but as your rules stand today, we are upholding it.
Correct.
So had we not extended the concession, our rules would have been as they are. Validity would remain as it is. and nobody would have been granted the benefit for standard 10. The fact that for 1 year and for another year, one concession was given, my submission, my lord,
The state
that's
must
a
always
law.
think whether or not to extend any concessions after, enforcing the rules.
My lord, concession cannot be claimed as a matter of right. Concession is in the realm
No,
of
that is only
policy.
a fair action on the part of the state.
My lord, in all fairness, 2
Yes,
years it was extended for
correct.
a minuscule, my lord, for a minuscule number of persons. We don't know the avalanche which we are going to be faced with once we open the admission next week. We have no clue of how many are going to come. The last year's figures which were given in the affidavit where the Honorable Court upheld the virus, 400 students had taken such admission. The state, my lord, having spent all the infrastructure, is not
Just 1 minute.
inclined.
Yes, Mr. Desai, you want to add something?
No, Milots, only to add this much, Milots, that the rule as it stands today has to operate for this year alone, last. Next year, if someone challenges, and
How can you take a decision for next year? Somebody may come up with some
no, I'm
point of
just saying,
challenge and may succeed. How can you?
agreed. I am saying that
You are concerned only with this year. That's all.
that's all, Milots. And because the rule works back, it goes retrospectively for 3 years. Therefore, this is the third year. Today, you cannot oust me, Milots. Page 18 is my domicile. I put my domicile on record, Milots. 18 is my domicile. That is not disputed. I did it. Another glaring fact is, Milots, after my term started, they've amended the rules, as I have already pointed out. Therefore, rule of proportionality or reasonableness, Milots, has to be tested. And this is not an obligation, Milos, as my learned friend is saying. They are not obliging, Milos. It is the rule has to work effectively only if it is extended for the last time. And earlier, my lords put a query to my learned friend, Milos, that earlier 2 notifications extending the benefit is for what purpose? Milos, better sense prevailed, and they had to do it because there were situations like the present one which arose that a person and you go in all India situation, Milos, of 15%. A bright student, Milos, it is not a fault of the student. They went for better education, better training, and she came back in 11th and 12th. Now you extend it to 10th. And after my term, Milos, please see the rules implications. The execution and implementation of the rule or the operation of the rule after the term starts. And there is an expectation, Milos, as far as I am also concerned, that 2 times they've done it. So there was, and I came back immediately. In 11th, I was back.
Right.
It was not that I was not back immediately.
Now, what is your rank in NEET this year?
Yes, Manoj. As far as 1 minute, Manoj. As far as the state is concerned, Manoj, my rank is 23,472.
And All India?
All India is 57,629.
Sorry?
57,629. I've secured 96.4 in 10th, 95 in 12th, and Manoj, there are. If I get in here, there are all chances, Manoj, that kindly see the implication of this rule, how it operates. If I don't make it this year, if there is no relaxation by the state this year, then then a person who is less meritorious than me may getting in the state quota. Kindly see the situation. The rule will work in a manner which is detrimental. That is not in public interest. It is not in the state's interest to implement the rule for 2 years and not for the third year.
Because that less meritorious student has cleared 10th standard from state of Gujarat.
Correct.
Yes, a person who has cleared 10th standard from state of Gujarat, 11th and 12th, and has got a rank would get in, and I would be out of this, and I would go in a 15% quota. I'm the first in the family who is being qualified for this medical science, Milots, and Lordships, as my Lord stated, that today there is a dearth of doctors, and as my Lord stated, Milots, for NEET, people go to what extent, Milots, to for education. She went in a boarding school in Kota from Gujarat because they were giving training in NEET, and she came back, Milots. Therefore, Milots, the petition before my Lords, Milots, and the Honorable Single Judge says it is a sympathetic consideration. I am not saying sympathetic. There is no rationale behind not extending it further.
All right.
Please, Milots.
Anything further you want to add?
We have yet not received the list from Milord NEE as yet, National Examination Board as yet. And till then, we do not know whether the petitioner with this ranking will also get in or no.
No.
All in the realm of conjectures.
Just by way of information, only sought the ranking situation.
Because one doesn't know, Milord. These are all arguments, Milord, on equity, Milord. Promissory estoppel, equity, fair play. And Milord,
the state is not acting as wise as it did last 2 years. That's the whole difficulty.
That's right. That is the only
reason. It is either...
there are very serious medical admission. There are very, very serious considerations to be taken into consideration. Individual hardships, Milord, cannot be a case to consider. We would be flooded. We would be flooded with outsiders. And these are matters which require very serious consideration at our end.
And it is not an outsider. This is your domicile, Gujarat state resident.
Milord, this exactly was pointed out when the virus is upheld. That Gujarat domicile, but outside, Milord, they don't stay back. At the first opportunity, Milord, they fly out. At the first opportunity, they're gone. And we need residents here.
Then you bind them. You say, if you are studying here in my state, in a college of the state, you have to work here for 5, 7, 10 years. Otherwise, you pay a bond amount of 50 lakhs or 1 crore rupees and see, they will work here.
All policies, Milord, have
been
frame
policies. You frame policies to get your votes, not to actually promote standard education. That's the whole difficulty.
No, Milord, Milord, with all due respect, Milord, our policies are formulated, they've been tested, and have stood the test of time.
Testing is something different, but the reasons for making policies is something different. The courts also have limited hands. We have heard Shri Anshin Desai, learned senior advocate, assisted by Ms. Sanskruti Shukla, learned counsel for the appellant, and Ms. Manisha Love Kumar, learned government pleader, assisted by
Milord, there was Mr. Kanwa Antani and Ms. Aishwarya Gupta.
Ms. Aishwarya Gupta and Mr. Kanwa Antani is there.
Was there? I don't know.
No. Did he come to the breakout room or not?
Yes, he was.
Mr. Antani, we did not see.
Mr. Desai?
Very well, Ms. Aishwarya Gupta.
Mamta Mohanty's case, you are relying upon?
Yes, Manoj.
Which part of the judgment?
1 minute.
Kind of education. I don't think the judgment is going to benefit you.
Not sure, give me a minute, Manoj.
क्या लिखा आपने? Mr. Aishwarya Gupta, learned AGP for the state respondents. With the consent of the learned counsel for the parties, we have heard the appeal at the stage of admission itself. As Ms. Gupta, we have noticed for the state respondents who were on advance copy. Okay. Orders reserved.
Plus, draft amendment may be granted.
Draft amendment granted. All right, Mr. Desai.
I'll just give the paragraph notes. I'll just give it to the.
You give it to the court master.
I'll do that.
Yes.
Please, Manoj. Oblige Manoj for a patient hearing.
Please, Manoj.
Next is government pleader and Mr. Ikrama Qureshi.
No, these are the matters where one group of applications where he was opposing the delay is reserved by your lordships. Other group is listed today. Bro.
Yes, Mr. Qureshi. Today, other matters are listed.
My lords, at serial number 23.
23.
Please, Manoj.
You will take up this matter along with 23.
My lords, please, as my lords. Please.
Right. इसको 23 के साथ दीजिएगा.
My lords would take it up when 23 is called out.
Yes, yes.
So I have permission to leave for the meanwhile, my lord, please.
We'll take you in again.
Please, my lord, please, my lord. Oblige.
Chirag Patel is Bharat Patel, right?
Yes.
Mr. Gadvi? Serial number 1 main court board में कोई और request है किसी की? No. Yes, Mr. Patel.
On the last occasion, this honorable court, the submission was made that we were served. There are, the issue relates to Section 81 notice, which came to be issued, and the honorable the submission was made that at the nth hour we are served, whilst 9 of the others are served well in advance. We 5 are the one who are not in consonance with the establishment. Grave injustice is done to us. We are served at the nth hour. When our representative advocate goes, he seeks time. No time, effective time is given. You pass an order, to which the honorable court said we were inclined to examine on the merits of it.
Right.
How have you processed the notice?
Correct.
Apart from the fact that it is at a show cause notice stage, the honorable court was inclined to know, that insofar as this service of notice is concerned, how have you dealt with this service of notice?
Yes, exactly.
That's right. The rest, my lord said, if you satisfy on this, we are not inclined to get into the other issues. We want to examine on this notice part, how have you dealt with it?
Can we just go through the order? 1 minute.
Yes,
We are refreshed of what we had said last time.
please, madam.
Sir, affidavit is received. Sir, affidavit is received.
Wait, Mr. Patel.
Give us the Gujarat Cooperative Societies Act.
Now, in compliance to this order, an affidavit has been filed by the district registrar.
That's right. That's right.
Now, that is an affidavit in reply by respondent number 3.
Yes. Milord,
Mr.
it's
S.P.
commenced
Chauhan.
with the index. I have given the index of annexures. Effectively, it starts at page 130.
130. We have the affidavit, but we don't have any index. And a rejoinder has been filed to this.
Sir, I received, only 1 minute. I received the same by Saturday night. I could learn it on Sunday at about 10 o'clock. And today, I was informed that it is not filed, but copy has been served to me. Can it be kept day after tomorrow? I will do the needful, or on Thursday, I will file it.
Well, just 1 minute. Let us first be prima facie satisfied what the affidavit says.
Yes.
Yes. What is your the stand of the district registrar?
Yes. Milord, the stand of the district registrar, I'm giving a brief genesis of the matter. Audit came to be carried out. I'm not giving the relevant provisions.
Yes.
Section 84 audit. Audit, it was found that there are financial irregularities. Auditor appointed by Milord, empaneled auditor, duly qualified chartered accountant, found that it requires a detailed inquiry. Therefore, under section 86, notice came to be issued, inquiry carried out, show cause notice issued, everybody heard, documents verified, all of it, culminating into an audit report. At no stage, Milord, did the committee members or the committee or the society ever deem it appropriate, necessary, Milord, to challenge or to upset it. These facts are all emerging on record. Be that as it may, pursuant to the inquiry report, 2 proceedings came to be initiated. One under section 83, the 93, and the other under section 81. 93 proceedings today, Milord, notices have been issued, are a subject matter of appeal before the appellate authority.
What is 93?
93 is fixing of individual liabilities,
All right.
individual responsibilities, all of which, Milord, is a subject matter of challenge in separate appeal proceedings, which my lords are not concerned with. Today, under section 81, which is the supersession,
Yes.
this is the subject matter of challenge. The
Correct.
prime argument which was made was that you have acted unfairly. You have issued notices to 9 of them within due time, enabling them to remain present and to make their submissions, whereas to 5 of us, grave injustice is done. You served us at the nth hour deliberately.
I said very specifically.
Mr. Patel, 1 minute. We can hear you.
To which, Milord,
Mr. Patel, 1 minute.
And other
let me complete my argument, since there is a query from the honorable
things
court.
should not be put in my mouth. I did not allege anything.
Milord, therefore,
I'm sorry.
Milord,
All right. You can always deny it later, Mr. Patel. Yes.
Milord, what weighed with the honorable court is the effective and meaningful fulfillment of principles of natural justice.
Correct.
Have you made sufficient endeavors? My submissions are at page 140, where we point out, Milord, at para 7.2, Shoko's notice was issued under section 81 on 29. Milord, it was issued to the managing director, who is the administrative head, with an endorsement to serve all. Managing director is directed to give us a report. Hearing is on the 6th. On the 5th, the managing director gives us a report that he has served. Para 7.3 begin. I submit that the managing director submitted a service report regarding the service to the members of the society. The copy of the service report is annexed, shows that 14 members out of the 19 have been served by him. Such 14 members include all the petitioners except petitioner number 6, 8, and 14. Therefore, all not served also not true. And why the others not served, Milord? Serious my lord, the Honorable Court take very serious, my lord, cognizance of the submissions in this context. All the petitioners except 6, 8, 14 and 16,
14
for
to
these
16,
five
that makes it
petitioners,
5.
yes, for
14,
these
15 and
5
16.
petitioners, 3 attempts were made by the manager to serve the copies of the notices. Details of these 3 attempts are as under. The manager, along with few employees of the petitioner society, first attempted to serve copies of the notices on 110. It is submitted that the manager went to the residence and telephonically communicated to the petitioner number so and so about such notice to be served upon them. However, they stated that they were not at their residences. They stated that they were not at their residences. A copy of the report or the Rojkam is annexed here too. It is submitted that on the 3rd, the manager, along with employees of the society, once again visited the residences of the 5 petitioners and made second attempt for serving the copies. However, the petitioners were not found at their home. On telephonic communication with the petitioners, they stated that they will come to the office and collect the copies of the notices. Furthermore, their respective family members also refused to accept the notices. A copy of the report is also annexed. On 5/10, the manager, along with few employees of the petitioner, visited the residences and made a third attempt for serving copies of the notices upon such petitioners. However, the petitioners were once again not found at their residences. Therefore, copies of the notices were affixed on the wall of the respective residences of the petitioners. Copy of the Panchnama is so and so. In respect of the service of the order dated so and so, it is submitted. A copy of the same was given to the manager of the society on 10/10, and a communication to that effect was submitted by the manager of the society to the deponent on 10/10. Copy of the said communication is annexed here too, etc. A perusal of the aforementioned sequence of events would indicate the following. The financial irregularities committed by the petitioner societies are being investigated into since 2017. The notice under 86 was issued to the petitioner on 17/5/18 pursuant to audit under section 84. Order for conducting an inquiry and appointment of inquiry officer was passed in 2019.
We have a question. Make us understand.
Please,
Come to section 81 first of the Act 1961.
Yes.
Supersession of a committee and appointment of a committee or administrator.
correct.
If in respect of a committee of a society having the registrar as its member, the state government, and in respect of a committee of a society which does not have the registrar as its member, the registrar is of the opinion that the committee persistently makes default, or 2 and 3, correct?
Yes.
Now, Ms. Shah, for arriving at the satisfaction or the reasons to believe that the committee persistently makes default, is it mandatory to initiate inquiry under 86?
It is not mandatory. It is not mandatory.
Okay. Now come to section 86. Before taking this decision, correct, to supersede the committee, your stance is that there was a full-fledged inquiry under section 86.
Correct.
Based on the report of that inquiry, this action has been taken, correct?
My submission is twofold. Milord, what the powers inquiry is either suo motu or on an application.
Yes. No. We just want to clear one factual aspect.
Yes.
Come to section 86.
Yes.
The registrar may of his own motion himself,
Right.
or by a person duly authorized by him in writing in this behalf, hold an inquiry into the constitution, working and financial conditions of a society.
Right.
Now, clause 2, the registrar shall hold such an inquiry. Just give us a fair idea. This case falls in A, B, or C?
It falls, Milord, in 86(1). 86(1).
You get the power to conduct the inquiry subject to clause.
Milord, this issue is no longer res integra. Milord, there are two aspects. 86 is in two parts, 86(1) and 86(2). 86(1) is where the registrar, either on his own motion or on a representation, takes a decision. Where
81
the
is not on its,
discretion
no,
86.
81 is not on its motion. So motion.
Milord, I'm talking about 86. 86 has two parts.
Correct.
86(2) is when a substantial number of members of a society so resolve, then the registrar shall. So the distinction between the two is that if he wants to do of his own or on a representation, it is 86(1). But if, my lord, on
Give
a
us a minute.
requisition by a
Give us
society,
a minute. Give us a minute.
So just one question. So according to you, 86(1) and 86(2) operate in different fields.
different fields, different.
Just 1 minute.
Yes, and actually 93 दशरथ बी के पटाना चेयरमैन सर No, Harris.
આમાંથી કેટલા ખબર નથી ચેક કરજો પછી ड्राफ्ट अवेलेबल છે
मिस्टर पटेल, हाँ अपना माइक ऑफ कर दीजिए आप जरा से। हाँ बहुत खटर पटर कर रहे हैं आप वहां पर। नहीं नहीं, वीडियो ऑन रहने दीजिए, माइक ऑफ कर दीजिए।
No.
Yes. Yes, Misha.
Please, my lords.
So can I request only one thing? I may be given 2 days time only.
Mr. Patel, just
Ah.
understand what we are trying to just see from the affidavit filed today. If we are not convinced that the state has made adequate efforts or the notices have not been served, we might as well allow your petition today itself and not adjourn it. But if we are convinced that the state or the managing director has taken steps and notices were served and you are at fault, we will grant you time to file a reply to this. All right? We are only trying to just understand what the affidavit says.
Yes.
Why do you get excited? हम मैटर को आपके खिलाफ नहीं
No,
डिसाइड
I'm
आप
not
लग रहे हैं तो.
Sir, I can never be
But
excited.
we called for an affidavit for on a specific point. So we are just trying to look into the affidavit whether
Sir,
that point which you urged is
Just I'm
taken care of or not.
I'm reminding the Honorable Court that last time it was what was transferred between us was that on 9th some people appeared, asked
At
for
what
time.
time? Yes.
What did you
Whether
do?
those persons were adequately served prior to 9th or they were served on 9th or before 9th after 6th.
No, my
That is
case was
what we are trying
served
to
on
see.
6th. Their cases we were served on 5th.
Patel, let us see from the affidavit. That's why we are not calling upon you to answer. Wait. Yes. Government leader.
Yes, my lord. So as I read out, my lord, I was reading para 8, pointing out, my lord, that what is the entire gamut, my lord, how my lord audit, thereafter inquiry, thereafter where individual finance, great. I've even enumerated, my lord, on merits, the financial irregularities, writing off of the stocks running
We
into
only
crores
want
of
to
rupees.
see whether service was
Service
effective well
is
in time or
complete.
not.
My lord, the prime contention would be of alternate remedy. It's an appealable order. But however,
Again, we had noted it in our order that there is a statutory appeal available to Mr. Patel's client and they can go there. But since it was vehemently urged that notices were not served and the action was taken in great haste, violating all norms of natural justice and fair play, therefore we called upon the state or the district registrar to file that affidavit
very
as
well.
to how he proceeded after 29/9/2020.
So I
The
again make,
answer lies in
again
para
make
7.
I
Mr.
did not
Patel,
that I was not solved with the notice. I said sufficient
Mr.
time.
Patel, we will dismiss the petition right here and now if you insist.
No, I will not suffer a single one. I will stop now.
आप you switch off your mic. आराम से बैठिए चुपचाप. Don't disturb the proceedings.
I will continue the mic, but I will not utter a single one.
That's all right.
Lord, in
You are running a risk. If you intervene in between, you are in trouble.
I will not.
Yes. Lord, in paragraph 7, as I had just read out, but
Yes.
I pointed out that notice was served to the managing director with copies to be served to each one. Managing director is the administrative head of the society. He was also given a mandate with clear instructions, my lord, to report due service. And my lord, endorsement to that effect of service of report be served, be made available to us. Total 19 members, 14, my lord, 14 duly served well within time, 5 evading notice, 3 endeavors made, report for each of the 3 dates on which endeavors made. Finally, service made by affixation, which is noted substituted service. And thereafter, my lord.
That affixation is made on 5th, right?
Yes, yes.
Very well. Thank you. Mr. Patel,
Yes, my lord.
you have 48 hours time to file your reply.
Yes, I want to file my reply.
देखिए,
Okay, can it be kept on Thursday? I will file the reply.
not Thursday.
Tomorrow I will file.
either day after tomorrow or next week,
Then Monday
Monday.
will do. Can it be on the top 10? That's the only request.
At 7 a.m.
So, no, top 10, I said. Top 10, I said.
There will be no disturbance at that time. तो पटेल आप भी कैसी बात करते हैं? लिखिए, we have heard. नहीं, pursuant to our order dated 20th October 2020, the District Registrar Cooperative Societies Banaskantha, Palanpur, has filed the affidavit in reply. According to the contents of the affidavit, and in particular paragraph 7, its subparagraphs, and 8, along with its subparagraphs, have given the details of the service of the notice dated 29/9/2020 on the 19 members of the executive committee. Full stop. According to the affidavit, in reply, the notice was duly served as per the report of the manager of the society. However, Shri B.S. Patel, learned senior advocate, appearing for the respondent, for the appellant, especially for the petitioner. This is a writ petition.
Understood.
Yes.
The petitioner raised for 3 days' time to file a rejoinder affidavit. Full stop. Time period for is allowed. Let this matter be listed in the top 10 cases on Monday next. क्या डेट हो जाएगी? 2nd November. 2nd November 2020.
Lordship, please.
Please, my lords.
एक लाइन बीच में लिख दीजिएगा. Ms. Manisha Lavkumar, and government pleader, has taken us through the relevant paragraphs 7 and 8. है ना? हाँ.
May I
Please,
crave
my lord.
Yes.
may I be permitted to leave?
Be permitted to leave. My lord.
Oblige. Grateful to my lords.
Yes.
Notes 2 and 3, I am
Huh.
requesting as far as the next two matters are concerned. 2 and 3, my lords.
What do you want?
I am only requesting time till Wednesday or Thursday, my lords, on 2 grounds. My lords, one is my colleague who was appearing is not available today. Secondly, there is a rejoinder served to us on Saturday, sir.
All right. Your colleague, Mr. Chintan Dave, is not well today.
No, he's not available only for today. No.
Ms. Parikh,
Yes, Your Lordships.
the state wants some time in this matter. It has received your rejoinder affidavit.
Yes, Your Lordship.
Today, Mr. Dave is not available for some personal reasons.
Please, Your Lordships.
So, when do you want it, Mr. Devnani?
But Wednesday or Thursday, subject to my lord's convenience, any date.
Wednesday, Your Lordships, in that case.
Wednesday.
Please.
Yes, Your Lordships. Can it be on the top of the board matters?
Ms. Parikh,
Yes, Your Lordships.
in item number 2,
Yes.
come to page 22. We want English translation of this part.
I've already provided in the
Where
on
is it? Where is it?
Lordship. I've sent it to the learned bench clerk, Your Lordships.
When?
Last time when the matter was listed for hearing on that very day.
Better forward it once again to Mr. Gadvi,
Please, Your Lordships. I'll do that. I'll do that.
because that's the only argument available to you.
Yes, it was already there. I'll provide it again.
Uh,
Can it be on the top of the board, Your Lordships?
yes.
the matter?
Both.
Sorry, Your Lordships.
This is already on top of the
No,
board.
for the next
Next date, Your Lordship.
रेती तो नीचे कर देगी. Second and third, both cases.
My
Yes,
lord.
Your Lordships. Both the cases.
देखिए भाई, rejoinder affidavit has been filed by the learned counsel for the petitioner on the request made on behalf of Mr. Chintan Dave, learned AGP, that this case be listed again on Wednesday in the top 10 cases.
Please, Your Lordships.
The Courtmaster has not received that translation, so you
Second.
better ensure
Yes.
to forward him right now.
Yes, Your Lordships. Right now, I'll do that.
Stay with you.
Please, Your Lordship. I'm deeply obliged and I'm sorry for the inconvenience caused to Your Lordships. May I seek Your Lordship's permission to leave?
Yes.
Oblige, Your Lordships.
अभी कौन आ गया इसको ज्वाइन करने के लिए सर इसमें?
हमने ही लगाई थी.
बहुत सारा इसको बंद करने पर कोई बात कर.
योगेश रवानी आएगा.
आएगा. अमित पंचाल, विवेक भामरे, रौनक चौहान will get you.
Please. On the Learned Advocate channel, I believe.
Yes, just 1 minute.
My lords, here I am requesting to join Mr. Ravani as he appears on my behalf, my lords.
Mr.
Ravani, Yogesh Ravani, my lords.
Mr. Yogesh Ravani. Mr. Raunak Chauhan, you have been wrongly taken in. You may stay or you may leave if you like.
Please, Lord. Please.
Please, my lord. Please, my lord.
Mr. Ravani,
Yes, this is joining party application, my lord. I am appearing for a person whose father had passed away in stray hospital incident. And no doubt this is PL for the benefit of those persons who had, my lord, suffered or victims of the stray hospital. And we want to assist your lordship on the aspect about the incident, wherein, my lord, the about notification which has recently issued, we tell that so far as hospital is concerned, it is liable, and simultaneously we want to show your lordship that the means so far as hospitals are concerned, there should be specific rules also, because having different, my lord, construction system and having number of instrument which requires separate rules also on this aspect. Therefore, we may be joined as party respondent in the matter. We will assist your lordships on this aspect.
very well. Yes, Mr. Panchal.
Yes, my lord. After the last order was passed by my lords,
Yes.
at that time, my lord, I had expressed certain reservations about the information which was to be given by the respondents. That
Yes.
affidavit, my lords, I have filed on 580 on page 585.
All right.
Lord, I have said a few things. Number one, after my lords had initially passed the original order, Lord, the first order, my lords had directed the state as well as the corporation on 17th of August to provide the information.
Yes.
Now that information was not provided in entirety. In fact, quite a bit of was not provided at all. And some of it was provided is not correct. Therefore, my lords, by the subsequent order dated 30th of September, permitted me to file the affidavit pointing out what I had to say, and also required the Learned Advocate General to place certain other material on record. Now, I have filed my rejoinder to the affidavit in reply filed by the corporation, which is at page 585, as well as the state respondent number 4. If my lords permit me, I can point out what was not pointed out by reading the affidavit. The first part of my rejoinder deals with the affidavit of the corporation.
Now, have you received this affidavit of the state?
Yes, both. There is one, Lord, the first affidavit of the corporation has been filed on 28th of September. Thereafter, the state has filed an affidavit. Also,
So this affidavit of 24th October 2020.
Yes, my lord. Yes, that also I've received, my lord.
Okay.
That what happened was there was an action taken report submitted to me. I had requested the learned advocate general that why should it not be placed on affidavit? That is why I believe, subject to what the learned advocate general has to say, they filed an affidavit yesterday, day before, yes, I'm sorry, on 24th. Now that is pursuant to the action taken report. They have transcribed it in the form of an affidavit.
Very well.
Be that as it may, I have filed an affidavit on page 585.
585.
Yes, my lords.
Pointing out what the state has not said.
That not said. Secondly, my lord, some orders are passed or some notifications are issued. They are only on paper. They are not even implemented in any form except being printed. The second aspect is the details of the various no objection certificates and various other aspects which were pointed out by me in the prayer clause have not been highlighted. And thirdly, most important, the state says that the corporation is an autonomous body governed by a separate act. It can appoint and do what it wants with regard to those appointments and vacancies. So the state does not have anything to say as regards that, but the corporations, though the vacancies are pointed out, no affidavits except the Ahmedabad Corporation has come.
Just 1 minute.
My lords.
Now, we would like to do a final hearing of this matter.
Very well.
Right. We had given a sufficient opportunity to the state and the Ahmedabad Municipal Corporation to file their affidavit. The state is to take care of the entire state of Gujarat, and the corporation would take care of the Ahmedabad state district only corporation.
Yes.
Now, whatever has come today before us for the first time, this 24th October, would you like to say something, file a reply to it, or not?
No, I wouldn't like to. I've said it.
May I say this wise, my lord?
Just 1 minute, Mr. Trivedi. Let me make things clear with Mr. Panchal and Mr. Ravani, and then we come back to you.
Gotcha.
All right. Now, Mr. Ravani, you have filed an application for.
Yes, I have filed application for joining party, and we want to further add one aspect that so far as hospitals are concerned, there should be specific rules because this
that you have mentioned in your affidavit in
application. No, yes, application we have stated. We want to elaborate that. That's only aspect.
Very well. So you don't wish to file anything further. You want to make submissions on that, right?
No. I will prefer if once I am joined, I can prefer file the further.
Whether you are, this is a public interest litigation. Your becoming a party is not all that important. Your assisting the court is relevant. All right.
That's true.
So if you want to file anything, you should have filed it with your joining application.
Very well. I will further file immediately, my lord, the material.
Right. In how much time?
1 week time, my lord, only. Or means any time your lordship fix as early as possible, I will do it.
Right, very well. Mr. Panchal, you don't wish to file anything further now?
No, my lord, but I would like to right now point out page 620.
We are not going into that right now.
It may assist Mr. Ravani. I'm not trying to in any way disturb the proceedings or prolong them. I have annexed at page 620.
You may exchange your affidavit with Mr. Ravani. If he finds that you have already taken up those points, he may not add by way of an affidavit.
No, he is a senior counsel. I don't want to advise him, but he can look at. I will share my
affidavit. Just sharing your affidavit.
Yes. I will do it today itself.
I
will do it today, and I request Mr. Ravani also to give me his application because I don't know what he wants to do.
Correct.
No, I am supporting the petition.
There is no question of supporting or opposing anybody. We are all trying to help the society.
I understand.
We got their interest so that proper measures of firefighting are taken in buildings which necessarily require it. That's all.
That's true. That's true.
Yes, Mr. Trivedi, now what do you have to say?
Lord, I wish to say this, Lord. I will.
Hey, give me just one submission. But I have pointed out after their affidavits that appointments have not been made. Vacancies in all the corporation and the state are like just 1 minute, my lord. They may take action. Otherwise, as many people, my lord, they plan to appoint. Nothing is being done. That's all I'm requesting.
Mr. Panchal, as I said, we are not hearing this matter today. We will take up this matter on the next date and do a final hearing of it. Whatever you have to say, whatever Mr. Ravani has to say, and whatever Mr. Trivedi has to say for the state and the corporation.
Very well.
For everything and take a final decision on the matter. If some directions are required to be issued, we will issue those directions. Whatever compliance has been made, we will incorporate that. whatever is lacking, we will direct the state to take care of that. Correct?
Very well. I'm obliged. I'm sorry.
Yes, Mr. Trivedi.
Yes, Lord. I was saying this, Lord. I'm not justified to claim that everything is in a hunky-dory state, Lord.
Correct.
Lord, we are determined to walk the extra mile, Lord. We have to do a lot of things. Therefore, Lord, whatever I have put in today, Lord, we have done this in a span from 30th, Lord, September 2020, when my Lord's passed the order. Lord, my Lord's first remark was that how can there be 8 corporations out of the coverage of the Act? My Lord's remark was absolutely justifiable. We immediately, Lord, took action. We tried to see that all 8 corporations are brought under the cover of the Act. My learned friend is right. We have to effect the appointment. My Lord's Padiwala, posed a query to me about the Nagar Palika. We have put on record that out of 672 posts sanctioned, as of today, there are only 79 people working. We need to see that those posts are also filled. Yes, Lord. That's a hard reality. I will not run away, Lord. But all that I would like to say, Lord, so long as this petition is pending, Lord, under the pressure, I am using that word, I am sorry for that. So we'll be able to do everything.
Mr. Trivedi, as you rightly said, that we are ready to walk a mile further.
Lordship.
Government will have to ensure with all Nagar Palikas to see that these posts are manned and filled up immediately. Why we are saying so?
Lordship.
Practically all Nagar Palikas will come with a begging hand, please give us finance. Because they have, every time, finance is a big problem for these Nagar Palikas.
My lords are right.
And that is the reason why they do not fill up the posts.
That will not happen. We are providing a finance for that particular purpose. We are putting timelines for the purpose of effecting appointment. We are trying to check each and every stage. We have checked up whether you have passed the resolution. All Nagar Palikas have passed the resolution. Now we have taken up the matter. Have you come out with the advertisement? Advertisement should be out within a day or two.
You will have to push this issue.
We'll push it.
Push this issue.
All that, I wish to say, Lord, let this matter be kept pending a bit for a longer time, Lord. We'll be able to do one after another. Otherwise, my lords will pass the directions. Tomorrow, my learned friend will come out with the content. These directions are not complied with. On the contrary, we would like to show that we are really serious.
You tell us a reasonable time. You tell us a reasonable time when you will be able to do the maximum.
Yes, my lord. The matter may be kept for time being beyond vacation, my lord. In the meantime, my lord, let us, my lord, perform. We may try to, my lord, satisfy my lord, and thereafter, lordship may think of passing the order.
And I'm okay with that. I'm okay. Just my lord, this is party. I'm sorry.
Lordship.
You may also make note of page 620.
Lordship.
We find a reference of the Clinical Establishments Registration and Regulations Act 2010.
Lordship.
Probably what is sought to be pointed out by Mr. Ravani
Lordship.
Can be taken care of effectively, provided you frame appropriate rules under this enactment.
I'll look into it.
Just look into it. Look into it. On the next date, you may assist us on this particular enactment.
I'll do
this enactment is of 2010, and it specifically deals with hospitals.
I quite see. I'll look into it. Certainly, I'll look into it.
This is what I was trying to point out when I requested my learned friend Mr. Ravani that I can assist.
No, we have noted it. We have noted it.
Just one more aspect, my lords. My lord, the Chief Justice, may kindly just have a look at one paragraph. Why I am saying this? This is in respect of the government dealing with Nagar Palikas and municipality. As far as the municipal corporations are concerned, the state on affidavit has said, kindly have a look at just one paragraph, page 407. Just 5 lines. Kindly look at it. Because they are saying that the corporations have to do everything. Page 407.
No, I can assure my learned friend.
My learned friend
have a concerted action.
I have no doubts. I have no doubts.
Corporations are also not bound down.
Yes, I am aware that.
Mr. Pachal, whether corporation does it, they don't do it, whether government would do it, we are here to do it. We'll see to it that corporation does the needful.
Just page 408 for just a minute. This is what the state says. I'm not saying it alone. Page 408, rather paragraph small 6, Roman 6. Roman 6. This is paragraph 16 on page 404.
So let us try to trace the proof.
Why is my learned friend so apprehensive about what I'm trying to point out? This is what
affidavit might ultimately let us prove through our action, my lord.
408, ground 6. They are raising their hand, the state. The state says, ground 6, paragraph 408, page 408.
My lord, if I had been, my lord, true with that particular contents, my lord, I would not have done what I have done, my lord, from page 621.
Lord, I'll point out page 621 at some point of time. 408, my lord, just
Noted.
So, my lord, my request is that the vacancies are known to the corporation. Let them do something by the next date. That's all I'm saying for the corporations.
No, I was very, my lord, lucid in my expression, my lord. I said the same thing.
He is always lucid, my lord. Only thing what concerns me are the facts which are stated on page 625.
Who would request the honorable court to keep the petition pending, my lord? My lord, let my learned friend appreciate, my lord. We are trying to put our all might into it, my lord.
But it is not enough. Sometimes somebody has to walk the extra mile with more effort. 27,322 buildings, 8,410 NOCs. 18,912 buildings not having NOC. But Diwali is coming. I am not doing it for any purpose.
Mr. Trivedi, this is a disturbing feature.
Likewise. So we have given the figure, my lord. Yes.
Your own chart, huh?
Yes, your chart. We are not running away, my lord. My lords are right, my lord. That's what, my lord. And I would like to see that, my lord, these people buckle up and get the needful done, my lord. Besides, my lord,
Mr. Trivedi said that I will file contempt. What else can I do, my lord? I can't buckle them up further.
Therefore, I say keep the petition pending. I think by next date, let us show that what we have done.
But state should show some more sincerity.
All right, Likhe.
Very well.
Pursuant to our order dated 30th September 2020, Mr. Panchal, the petitioner in person, has already filed an affidavit pointing out
Pursuant to order dated 30th September 2020, Mr. Panchal, the petitioner in person has already filed affidavit
pointing out the deficiencies. Full stop. Shri Kamal Trivedi, Learned Advocate General, representing not only the state but also the Ahmedabad Municipal Corporation, assisted by Mr. Satyam Chaya and Mr. Dharmesh Devnani, Learned DGP, has not only filed a 3-page note of the action taken report on behalf of the respondents, but has also placed the same by way of an affidavit. Mr. Trivedi has further submitted that the state is already geared up to take all possible steps to ensure the life and safety of all under the provisions of to ensure that to make sure that all buildings requiring the NOC from the Fire Safety Department are taking all steps to put up all the necessary implements and make necessary provisions and obtain necessary no objection certificates. He further submits that in case a reasonable time is allowed, the state, which is already in the process would come up with further action taken report, not only in terms of infrastructure, but also not only in terms of material infrastructure, but also procurement and placement of human resource throughout the state to deal with the firefighting. ठीक, full stop. Next paragraph लिखिए, श्री योगेश रवानी, advocate for Mr. Vivek Bhambre, counsel appearing for the intervener, submit that he would also like to add as to how the what would should be the relevant rules framed for hospitals to deal with the firefighting equipment and the necessary NOCs. Tick, full stop. Shri Ravani may also file an affidavit within 2 weeks after serving a copy of the same not only on the petitioner but also to the state. Let this matter be now listed December की second week में 14 को list on 14 December 2020. Full stop. The state and the Ahmedabad Municipal Corporation would file their respective further affidavits on or before 10th of December 2020 after serving a copy of the same on the learned counsel on the petitioner as also the learned counsel for the intervener. Tick.
Gotcha. I'm grateful.
If it appeals to my lord, the corporation may also make an endeavor because, my lord, of for filling the vacancies. There is enough time. That's all I'm saying.
Trivedi appears for the state as there is a corporation.
But
And
only
the
Ahmedabad.
corporation works under the state. It is not, it is only an extended wing of the state government, nothing more than that.
Lord, Mr. Trivedi unfortunately appears only for Ahmedabad Municipal Corporation. We have 7 others which are not represented.
I can assure my
Under
learned
the state only, right?
Very well.
I can assure my learned friend will leave no stone unturned, my lord.
Lord, I have been hearing these assurances. I have great respect and regard for my learned friend, but action has not been taken. That's all I'm saying.
Let us see. Let things speak for themselves, my lord. Rest
Yes,
shall
yes.
equitable.
Or the next time, get this matter in greater detail
Very
and
well.
see what exactly the state has done in the last 3 months. Otherwise, the state
Yes.
will be taken to task.
Lord, I will assist in that behalf, Lord. I'm sure.
Yes.
Obliged, Lord.
Gotcha.
20 years back, Mr. Panchal initiated these proceedings without a beard. He has a beard which has grown grey.
He has wedded to the cause.
Yes.
Lord, Mr. Trivedi has also been always Lord, assisting as well, helpful. I don't mean anything against Mr. Trivedi. In fact, because of him and my lords, my lord, this is moving. I'm grateful, my lord. That's all.
Lord,
I may be permitted to leave. Right.
Yes.
Lord.
We are obliged.
Yes, Mr. Devrani, what is this next matter?
My petition is filed in the year 2019, challenging the order of suspension passed in the year 2011. In other words, essentially, this is a petition where I would humbly urge your lordships would be an interpretation of the rules, more particularly discipline and appeal rules of the state government. A few details, ji sir.
Ultimately, you initiated departmental inquiry and dismissed him from service, na?
Show cause notice. Oh, it is, we have not moved ahead. Departmental proceedings have not been initiated.
Delinquent was served with a charge sheet.
Show cause notice. I have taken specific instructions. We have not initiated departmental proceedings.
Show cause note, calling upon him to show cause. Why? What cause? That why you should not be dismissed from service?
No. I would humbly put it this way, this is a case of deemed suspension.
सर उसको सस्पेंड कर दिया 11 में और आज तक इंक्वायरी नहीं प्रोसीड किया.
I'll point out, Lords. Lordships may kindly consider the rules.
Just Mr. Devnani,
Please, my lords.
what happened to the criminal prosecution?
That is pending. That is pending.
Now, has he attained superannuation?
No, he says no, he has not yet. 90 is his date of joining. He has not. He still has some service, Ji, sir.
His suspension is on account of those criminal cases.
Ji, sir.
He was in custody for more than 48 hours.
48 hours.
And the offense is relating to his departmental working in the office.
I am grateful. Yes, sir. The offense is that when he was working as a town planner.
Now, show us that rule of 90 days. Within 90 days, it has to be reviewed. Show
Page
us
107. Page 107. I am obliged, Manoj. In fact, this is the rule which is required to be.
Wait a minute.
Please,
read that relevant rule, please.
Page 108, rule 2A, because he'll be falling under category 2.
Wait a minute.
Ji, sir.
A government servant shall be deemed to have been placed under suspension by an order of appointing authority. Now, in this case, he was arrested by the police.
I am obliged. Yes, sir.
He remained in judicial custody for how many days?
For more, because he's granted bail after filing of the charge sheet. Therefore, more than Ji, sir.
Understood. Now, you are invoking A ke B.
2A.
With
subclause A.
The date of his detention, if he is detained in custody, whether on a criminal charge or otherwise, for a period exceeding 48 hours followed. Now show us that 90 days rule.
Next, 2A.
Next page, 109, provided that no such review. Am I with your lordships?
No, first read the review. An order of suspension
2A padhiye na.
made.
Ji. Deemed to have been made under this rule shall be reviewed by the authority competent to modify or revoke the suspension before expiry of 90 days. The effective date of suspension. After such review, the competent authority may pass an order either extending or revoking the suspension. The suspension review shall be made before expiry of the extended period of suspension.
Now go to the proviso.
I am obliged. An order of suspension made or deemed to have been made under sub-rule 1 or 2 of this rule shall not be valid after a period of 90 days unless it is extended after review for a further period of 90 days.
It's very clear.
It shall have to be made within 90 days.
Proviso.
I am obliged. Provided that no such review of suspension shall be necessary in the case of deemed suspension under sub-rule 2, which is my case.
If the government
servant
continues to be under suspension at the time of completion of the 90 days suspension, and the 90 days period in such case will count from the date of government servant in custody.
Your this proviso is in direct conflict with the rule which you just read. And
please, Manoj.
An order of suspension made or deemed to have been made under sub-rule 1 or 2 of this rule.
Please, my lords.
Shall not be valid after a period of 90 days unless it is extended after review for a further period. Correct?
Please, my lords.
Now read the proviso.
Provided that no such review of suspension shall be necessary in the case of deemed suspension.
Deemed suspension is included at the top. Read it.
In 1 and 2. 1 and 2.
If the government servant continues to be under suspension at the time of completion of...
I will point out, Manoj, why this proviso. As far as the first proviso is concerned, it is very categorical.
मेरे हिसाब से ये इंटरप्रिटेशन सिंगल जज का गलत है सर. मैन
And with respect, Manoj, the learned single judge has considered one case, identical case, but that was not a case of deemed suspension. Their departmental proceedings were initiated on account of...
There is delay in this appeal.
Please, Manoj, I am at the stage of delay. Lordship, I'll request for issuance of notice on both delay and the appeal.
How many days delay?
I am at delay of only a minute. I'm sorry, only a minute. 213 days.
213 days.
You have reinstated him.
No, we have not. We are still before it. My lords.
We have heard Shri D.M. Devnani, learned AGP for the state appellant, issue notice on the delay condonation as also the appeal, returnable within 4 weeks.
I'm highly obliged, lords. I'm grateful.
Just on the date mentioned in the notice.
Please, my lords.
The next one is a similar matter.
No, next is a matter. No, it's a different matter, my lords.
Then
But
we'll
next
take it
again
up
is a
after
matter.
lunch.
Very well, very well. Please, my lords.
Lunch back करेंगे.
I'm obliged, my lords. May I leave with my lord's permission? Please.
Yes, Mr. Trivedi.
Please, Your Lordships, here in identical LPA, my lords have passed an order dated 17/9/2020, whereby the LPA has been admitted and CA has been disposed of by granting stay in accordance with compliance to 17B, Your Lordships.
All right. What is
That
the
order has been passed in LPA 554 of 2020. Similar order needs to be passed in this matter also.
554 of 2020?
Please,
No,
Your
the
Lordship.
lead matter is 494 of 2020. The order by your lordships is 4920. That's the first matter where your lordships are pleased to admit the appeal of the state and grant stay.
Mr. Deepak Dave appears in all these matters.
Please, ma'am.
Of 554 का order की date क्या है? What is the date of the order of 554?
That is 17/9/2020. Your Lordship.
Same order is to be passed, except name में change होगा. Miss Nidhi Trivedi, advocate, appears for Mr. Deepak R. Dave, counsel for the respondent.
Please, Your Lordship.
Connect कर दीजिएगा उसको.
Please, Your Lordships.
Right.
I may be permitted to leave, Your Lordship. Please, I'm obliged.
What is the next matter, Mr. Devnani?
But this is under the Agricultural Land Ceiling Act, my lords. It has a checkered history. But just to start, my lords, as far as this litigation is concerned, my lords, I would urge before your lordship that as far as right from the year 81, sorry.
Mr. Devnani, there is one hurdle for you.
My lords.
Single
Delay.
judge has not gone into the merits of the order passed by the Revenue Tribunal.
My lords.
It took 7 years for you to challenge the order of the tribunal.
And almost 2 years to challenge the order of the single judge.
We believe we should not interfere, Mr. Dev.
I understand. I will only urge your lordship to grant me 5 minutes, and then if your lordships are inclined not to consider my case, because I understand I'm at a delay, but I may not be non-suited on this ground of delay, because on merits only 2 minutes I'll take from my lords.
Last week, Supreme Court has passed an order commenting on the delay on the state authorities in filing appeals. They cannot come at any time or something like that. Some observation has been made. Justice called order है. उसको निकाल print out दीजिए मुझे.
Please.
Proposal was forwarded in 1991.
Please, my lords.
It took 5 years for you to ultimately take the final decision. And in 1996, opinion was obtained from the GP of the tribunal.
My lord.
And sanction was accorded after 4 months by the legal department.
Please, my lord.
Therefore, the single judge observes, apart from 5 years of unexplained delay from 91 to 96, even after sanctioning approval by the legal department in March 96, more than 1 year and 6 months elapsed till the date of filing.
Lords, I understand, Lord. There is as far as delay is concerned, I'll have to satisfy your lordship. I have an answer to this, Lords. It is also our case. It was also our case before the learned single judge that it was not this one case which was to be considered by the department. There were 700 such cases on the interpretation of 6(3)(b) of the Land Ceiling Act which were considered by the department. Lords, there is one more aspect, Lords, as far as this petition is concerned. It was in fact at one point of time allowed in favor of the state government. There is an order passed by the learned single judge allowing my petition. appeal was preferred against the order of learned single judge by which that petition was allowed, that appeal is withdrawn with the view of filing review and recall application before the learned single judge again. That recall application was preferred before the learned single judge with a delay of 266 days. The learned single judge was pleased to recall it only on the ground that the learned advocate for the opponent was not heard. Now, I would therefore urge before your lordship, my lords, please consider my case on merits, because this is a petition where I have succeeded once. On recall only on the ground that he was not heard, the learned single judge was pleased to recall this order, my lords.
Which order?
This very petition. There are, if your lordship, my lords, I have given three
orders. Order of the single judge.
To the court master, I have given 3 orders. If your lordship can kindly call for in the morning, lords.
The court master, 3 orders have been given by Mr. Devnani to you. Like,
so this order, which is at page 13,
please, my lords,
is after the order passed by the High Court.
No. This order
I point out
by the High Court.
This was
but there is first order of learned single judge allowing this petition.
There are 3 orders given by. Yes.
But there would be one order of my Lord Justice Soni, my lord.
Justice Soni's order is 16 June 2012.
In 7599 of 98, this very petition.
Yes. And this petition was allowed.
It is allowed, my lords.
Quash and set aside and declare the respondent shall be entitled to only 1 unit. That is, respondent will be entitled to hold total 36 acres of land. Order passed by the collector dated so and so, civil division application declaring the land will so and so as surplus is confirmed. The petition is allowed accordingly. Rule is made absolute to the aforesaid extent. The tribunal's order was set aside.
I am obliged. This very petition, Manoj.
Now, thereafter, a recall application was filed.
Thereafter, an appeal is preferred against the order of learned single judge, which is withdrawn
by the before the division bench.
Before the division bench, with a view to preferring, prefer a recall application of this order of learned single judge, and only on the ground that he is not heard, the petition, the order was recalled.
What is the date of that order?
Of the honorable division bench.
The respondent was not heard.
Yes.
It
was allowed against the GRT staff.
But apart from everything,
dismissed it on the ground of delay.
So he
apart from it,
appeal against which order? Single judge order.
Now, similarly, Justice Anjaria has dismissed the petition on the ground of delay only.
Ananda
on the ground of delay only of 7-8 years. Right, but he says कि in 2016 this petition itself was allowed.
इसका तो कोई reference ही नहीं आ रहा है.
उसमें नहीं आया कि.
यहाँ पे तो कोई नहीं आ रहा.
But this reference of this earlier order of 16 June 2012 doesn't find place in the.
Unfortunately, it is not finding a part of record. But nonetheless, apart from sir.
Was it pointed out to the learned single judge? The entire history of this litigation. We are sure that if it would have been pointed out, probably
would have considered. Manods, last request to the Honorable Court, Manods. Please test my case on merits. Only for 2 minutes, I'll be able to satisfy your Lordship that this is a case where the order passed by the tribunal is ex specie contrary to the provision of law.
Now take us to that order of the tribunal.
Page 13, my lords.
वो हो गया सर. वो State of Gujarat ने challenge किया. State of Gujarat succeeded. फिर
टेनर होल्डर गया अपील में.
ये त्रिवेदी ने
अपील करी.
अपील की थी, विड्रॉ कर दी.
अपील विड्रॉ कर ली.
Right.
लिबर्टी मिल गई सिंगल जज के यहाँ फिर जाने के लिए.
Same judge. Right.
Now that order was recalled. This order was recalled
on the ground
that he was not heard, and the writ was allowed without hearing the tenure holder.
And it should go back to the single.
Consider the matter on merits. Actually,
I don't recall हुआ.
नहीं recall होने के बाद तब साहब ने फिर decide किया और फिर dismiss कर दिया state की petition को on the ground of delay without entering into the merits. ये कह रहा है.
So the ground on which this order passed by learned single judge, which is impugned,
my lords,
did not weigh first in point of time.
Yes. No,
it did not. I am obliged. It did not, and on the contrary, the honorable division before the honorable division bench appeal is withdrawn. Therefore, on merits only 2 minutes, sir. Ex specie only. I will not take more than 2 minutes.
ठीक है.
अभी फिर डिले करके आए क्यों 2 साल की?
Sir,
Sir,
just
kya?
for
Everything, sir. We'll apply the Supreme Court judgment and dismiss your appeal.
sir, therefore, at the outset, I pointed out, I may not be non-suited, but I have a case on merits, Manoj. Therefore, on
Okay.
technical ground of delay.
We have heard Sri DM Devnani, learned AGP for the state appellate. Issue notice on the delay condonation as also the appeal, returnable within 6 weeks.
This is from Surat.
Yes, sir. Yes,
Surat.
sir.
Priceless.
Priceless.
So, Lordships are aware, Manoj, why these delays. Please, I will not be able to speak. I am highly obliged. I am highly obliged.
Devan,
Lordships.
Mr. Siti Jamil will appear in item number 8.
Mr. Tirth Nayak.
Mr. Tirth Nayak.
Lord, I appear for the original appellant, my lord.
Wait. 1 minute.
Mr. Anuj Trivedi's application is there.
Just 1 minute. Tirth Nayak.
He is with me, my lord. He is appearing with me.
Okay. Mr. Tirth Nayak is there with you only?
Yes,
Or
yes. He is with me.
Okay.
Yes.
Very well.
The appeal has been admitted.
Yes, my lord.
My lords, the appeal of Mr. Bhatt has been admitted. It is posted for final hearing.
Hearing for by way of this civil application.
My lords, my prayers are at page 5. My prayer is that I may be permitted to either intervene in the LPA or alternatively, my special civil application may be called for and be heard along with the LPA.
Who are you? Who are you?
My lords, I have filed a similar petition. My petition was prior in point in time then compared to Mr. Bhatt's. What has been impugned in my petition is at page 7, which is order of the stamp authority. The issue is whether under Article 20D explanation 3, whether the stamp duty could have been levied or not. After my petition was filed, Mr. Bhatt...
Your transaction has nothing to do with the transaction of Mr. Bhatt.
No, my lords. But the point of
identical issue is involved.
Yes, question of
Identical
law is
point
the
of
same. It's only a
Identical point
question
of
of law.
So why should you be implemented in this matter? Why should you be implemented? You can get your matter connected to this matter at best.
My lords, that is my prayer.
Alternative prayer is that only.
Para 9B is that.
This is pending before single judge.
My lords, my petition is pending before the single judge, and the outcome of LPA would bind my petition. Hence, the request is that my lords may hear the LPA as well as my petition together.
Why? Once you can take benefit of this judgment, whether if it is in your favor, you show it to the single judge. If it is against you, you argue your matter independently.
The issue is same, my lord. It can be heard.
My lords, the issue is the same and the point of law is the same. So both can be heard together and put an end to.
All right. Mr. Bhatt, do you have any objection to Mr. Trivedi?
No, my lord. I have no objection because we are sailing in the same boat. Same issue is there.
What is the number of your SCA?
My lords, SCA 18387 of 2018. Para 9B, page 5. 18387, 2018.
Prayer 9B is the same.
9B, page 5.
Yes.
We have heard Sri Anuj Trivedi, learned counsel for the applicant, Sri Amar Bhatt, learned counsel for the appellant, and Sri Shiti Jameel, learned counsel appearing for the respondents.
And the state is also necessary. You collect, my friend Mr. Devnani would be appearing.
Mr. Dharmesh Devnani, learned counsel appearing for the state respondents. And Mr. Shiti Jameel ki likhiyega, learned counsel appearing for
number 3.
Respondent number?
3, man.
So 5. In the CA, he is number 5.
That's all right.
In the civil application, he is number 5.
All right. Number 5 कर दीजिए भाई. बाकी 1 to 4 के लिए Mr. Dharmesh Devnani कर दीजिए.
No. 1 and 2, I will be appearing.
हाँ. ऐसा लिखिए, काट दीजिए पूरा. We have heard Sri Anush Trivedi, learned counsel for the applicant in application for intervention. Bracket with CA number 2 of 2020. Comma Shri Amar Bhatt, learned counsel representing opposite party number 1 and 2. Comma Shri Dharmesh Devnani, learned AGP representing the state respondents number 3 and 4. And Shri Kshitij Amin, learned counsel representing respondent number 5. Full stop. By means of this civil application, the following relief has been claimed. Quote kar dijiyega. Full stop. Having considered the submissions, we are of the view that the special civil application number 18387 of 2018, filed by the present applicant, namely CPL Holdings LLP,
Lordships,
may be heard along with this appeal, as according to learned counsel for the parties, there is an agreement that the issue involved is identical and is a purely legal issue.
Yes.
Tick. Full stop. Accordingly, we grant relief as prayed in para 9B of the application. Let the special civil application number 18387 of 2018 be clubbed with LPA number 125 of 2020, and both may be heard together. Application stands accordingly disposed of.
Lordships.
May I request that it can be listed for final, because only short issue is there. If after Diwali it can be listed, so that
list in the first week of January 2021. Yes.
That will be too long.
No, not too far. Very close.
Please.
पता नहीं चलेगा भी निकल जाएगा time. Yes.
Please, obliged.
Lordships, obliged. We will leave, my lords.
Yes.
Obliged.
Lordships.
Mr. Wasim Mansoori and Ruben Purohit. Ruben Purohit.
इसको लीजिए, सुनीत शाह को लीजिए।
वसीम मंसूरी।
Very unusual clarification. कुछ पता ही नहीं चल रहा है इसमें क्या। Mr. Yagnik, still time, sir. Still time. Still time for you.
I appreciate your lordships. Since I'm brought
yes.
from a waiting to before your lordships.
Yes.
So I will take back my car again to the parking.
हमने ऐसा कहा सर. Letters patent appeal is accordingly dismissed, having been rendered infructuous, leaving it open for the appellant to assail the order of the Charity Commissioner, Joint Charity Commissioner, Rajkot, dated so and so. The appellate authority shall decide the said appeal on merits and would not be influenced by any of the observations made by the single judge on merits of the matter, as they were unwarranted in view of the reliefs claimed by the petitioner in the writ petition. You want
to first? There are first is miscellaneous civil application preferred by me, Milord. 1 of 2020.
Yes.
Lordship was pleased to pass an order. Operative part I have reproduced in paragraph 2. Later patent appeals is accordingly dismissed, having been rendered infructuous, being leaving it open for the appellant to assail the order of the Joint Charity Rajkot in appropriate proceedings. The appellate authority shall decide the said on merits and would not be influenced by any of the observation made by the learned single judge merits of the matter, as they are unwarranted in view of the reliefs claimed by the petitioner in the writ petition. The appellate authority shall decide the appeal independently on its own merit on the basis of the materials placed before it, strictly in accordance with law. that at the time of hearing of the said appeal, counsel was under the impression that appeal may lie against the order of the Joint Charity Commissioner Trust and therefore made submission. But looking to the provision of the...
Where are you reading, Mr. Shah?
Yes.
The order comes to an end at para 7.
Yes.
You read something in addition to para 7?
No, I was reading the para 3 then. Para 3 of my application.
My lord, Mr. Shelat may be joined, my lord.
And 4 is my... I want that word appeal and the appellate authority substituted for the words appropriate proceedings and appropriate authority, because the appeal does not lie. I mean, this is in the light of the spirit of the order. Appellate authority.
And what is your civil application, Mr. Purohit?
Mr. Shelat is there, my lord. Mr. Shelat, Lord, this may permit my respected senior to, my lord.
No, we have no objection in correction, but we also want some correction. My lordships will look at the order. The appellate authority shall decide the said appeal on merits.
Just 1 minute, Mr. Shelat, 1 minute. Now, Mr. Shah.
Yes, my lord.
Do you have any objection to his application being granted?
Sir, I don't have any objection.
All right.
Sir, only the paragraph 4A.
Now enough. We are allowing both your applications.
No, only that typographical mistake. Word appellant is written. It should be appellate.
That's all right.
That may be correct. I may be allowed to correct. Appellant. N has cropped it.
In paragraph 4.
4A. 4A. Appeal and it should be appellate authority. It is written appellant.
Yes.
Okay. I need to correct it.
Appellate authority.
Appellate authority.
So you say it should be appellate authority. Appeal and appellate authority should be substituted with the words appropriate.
Appropriate authority.
Appropriate proceeding and appropriate authority should be deleted, and in its place appeal and appellate authority should come.
Yes.
Correct?
Appropriate proceedings and appropriate authority. Appeal should be replaced by the word appropriate proceedings.
And appellate authority.
Appellate authority should be replaced
by appropriate authority.
Yeah, appropriate.
Achha, all right. Likhiye bhai. We have heard Shri Sunil Shah, advocate for Mr. Wasim Mansoori, learned counsel for the applicant in MCA 1 of 2020. And Shri S. N. Shelat, learned senior advocate, assisted by Shri Murugan Purohit, learned counsel appearing for the applicant in MCA number 2 of 2020. Okay. Both the learned counsels have appeared for the opposite parties in the separate applications. अब आगे लिखिए. MCA number 1 of 2020 has been filed with a prayer to substitute the words appeal and appellate authority occurring in the operative portion of the order by the words appropriate proceedings and appropriate authority. Full stop. Meaning thereby that the word appeal and appellate authority be deleted and be substituted by the words appropriate proceedings and appropriate authority. Full stop. Shri Shelat, learned senior advocate, appearing for the opposite party in this application, has no objection to such corrections being incorporated. Full stop. Accordingly, we allow MCA number 1 of 2020 The operative portion of the judgment and order dated 6/10/2020 to be read as above. That is, the word appeal and appellate authority be deleted and be substituted by the words appropriate proceedings and appropriate authority, respectively. Next paragraph. While MCA number 2 of 2020, it has been prayed that the operative portion of the order reading as follows, पेज 7 में यहाँ से यहाँ कोट करिए, reading as follows, may be substituted by the following sentence. और जो ये हम इसको बी मार्क किए दे रहे हैं, ये बाद में आएगा, जो ए है वो पहले आएगा, राइट? ये ए है, may be substituted by the following sentence. ये कोट कर दीजिएगा नीचे उसको, full stop. In effect, the only change required is that the words as they were unwarranted in view of the relief claimed by the petitioner in writ petition may be deleted. Full stop. Although nothing turns upon these words, but nevertheless, whatever be the sensitivity or delicacy involved, learned counsel for both the parties agree that the relief granted may be now read as requested. Okay? Accordingly, MCA number 2 of 2020 is also allowed. The operative portion of the judgment and order dated 6/10/2020 may now be read as observed above. That is, the words A quote करिएगा, words A be deleted and be substituted by the sentence B. ठीक?
Milord, there is one suggestion. I may point out to Mr. Sheller. If your Lordship will kindly see, again, they are also referring as appellate authority and the word appeal. So that should be really... No, it should be really appropriate authority and appeal.
Yes.
Appropriate proceedings in their paragraph also. Lordship will, otherwise this will create confusion. Lordship may kindly see.
No, the order is only one. Where is the confusion?
No. Appellate authority shall decide, the appropriate authority shall decide the state appropriate proceedings.
State appeal को या appropriate proceedings हो जाएगा. जब वो allow कर दिया तो automatically correction हो जाएगा.
That's one point. It should be that way.
ली, ठीक? तो हमने correction किया, इसी तरह से कर दीजिए correction, ठीक?
Yeah, here also the same thing. Obliged.
Please, we are obliged. Please, with my lord's permissions, may we leave, my lord?
Yes.
Permission.
Please.
We have Mr. Mukesh Mishra. Mr. Gadvi, is there any message in this matter?
No.
Mr. Mukesh Mishra?
It says and he is requested to send mail.
Who has sent? MT Mishra has sent?
Yes, I already said.
You've already said? Just find out whether he is joining or he is not joining. And he has come. Yes, Mr. Chauhan, this is your application or Mr. Mishra's application?
Mishra's application, Lord, for vacating stay granted by your Lordship, Lord.
Acha, why? On what ground?
That
Your Lordship,
he has not been.
I am the applicant. Your Lordship may kindly hear me.
Mr. Chauhan, you want to file a reply to this application?
I have already filed, Lord.
You filed your reply?
Yes, Lord.
When?
Lord, page 49 of my reply, Lord.
It is not here. We have only till page 48 the Supreme Court order.
No, my is at page 49. I filed 4-5 days back, Lord. I filed, Lord.
Mr. Chauhan,
please, Your Lordship.
The appeal preferred by you, your challenge is confined only to continuity of service or the very award passed by the Labour Court?
Lord, continuity I am not challenging, Lord. I am challenging on the basis of reinstatement. The Honorable Court, Learned Single, has granted 171088 benefits. That is a regularization, promotion, revision of pay, pension, and everything. And for 22 years, he was out of service.
That is absolutely incorrect, my Lord. Your Lordship may kindly see his reply. He himself has agreed that he is ready to pay the notion, and I am not teaching any.
Mr. Chauhan's rejoinder reply to your application is not on record. So we will require the registry to place it on record and we will fix it for some other date next week. All right?
Please.
But
well, serial number 27 also, because this is interconnected. There also the petition is admitted. And on page number 27 is a fresh matter that may also be taken along with this.
लिखिए, Mr. D.G. Chauhan, learned counsel for the appellant dash opposite party in the application, states that he has filed a reply to the stay vacation application last week, full stop. The same is not on record. Office will trace it out and place it on record. List again on 5th November 2020.
Please.
Along with serial number 27, same issue is involved. Serial number 27.
वो तो मिस्टर मुंशा का मैटर है.
हाँ, but issue is the same. Common order.
भाई उसमें तो कोई स्टे वेकेशन एप्लीकेशन फाइल नहीं किया आपने.
That is fresh matter, my lord.
Why should you unnecessarily create complication for us?
The issue is the same. Therefore, I was.
The issue is the same. How does it matter?
Lordship.
Please.
Yes.
May I take leave, Lord?
Yes.
Give us the number of their holdings matter. Holdings. Only one matter. First matter.
Mr. Hitesh Acharya.
वो जजमेंट प्रोनाउंस हो गया सर.
वो वाला.
हाँ, 386.
अजय जागीरदार वाला.
जी सर. 386(2) has been declared to be valid, and so far as quantum is concerned, the matter is referred to the government.
Mr. Hitesh Acharya मिले तो पहले कहाँ हैं? Mr. Hitesh Acharya has represented to somebody else.
No one. He appears, sir.
SCA 45 2019. Okay. Judgment pronounced on
last Friday.
20th.
Friday.
Okay.
No, not Friday. It was
Tuesday.
My lord.
So Mr. Hitesh Acharya is not here. What to do?
So we dispose it of.
कर दी.
लिख दो.
Mr. Devani would be appearing for the state
corporation, sir. He will appear for the state.
My lord.
This is Ahmedabad, so Satyam Chaya will appear.
Please.
By this writ application, sorry, pehle likho, Mr. Hitesh and Acharya, the learned counsel, appearing for the writ applicant, is not present at the time when the matter was called out. Full point. We have heard Mr. Dharmesh Devnani, the learned AGP, appearing for the respondent number 1, State of Gujarat. By this writ application, under Article 2 to 6 of the Constitution of India, the writ applicant an advertising agency has prayed for the following reliefs. Quote, a coordinate bench of this court, vide judgment and order dated 20th October 2020, passed in the special civil application number 4538 of 2019 and allied petitions, has upheld the validity of section 386(2) of the Gujarat Provincial Municipal Corporation Act. Full point. In such circumstances, we need not adjudicate this writ application on merits. This writ application would be governed by the judgment referred to above. Full point. This writ application accordingly stands rejected.
Yes, in serial number 13, Senior Advocate Mr. Joshi appears. He is before another court. May I request for a passover?
All right.
All right.
Passover, you want Passover for the day or you want Passover for some time?
No, Miloj, Passover, Miloj, at the end, maybe end of the word. He should be done in about 15-20 minutes is the message that I've got.
Already
Subject to the court.
Pastor, after
very well.
Joshi is free.
Very well. Very well, Miloj. Deeply only.
Tran 1 is coming up on which date? After vacation.
Yes, this is a matter.
The other matters are coming up on which date?
Lords, here, in fact, my lords have already passed an order directing grant of credit. They are not complying with the order.
Why have you come again?
Because, my lords, the state is also representing the GST and the network is saying that we are not in a position to comply. We had come before the authorities. The authorities made a statement before the court that we have directed the network to grant the credit, and therefore, in view of that statement, the earlier petition was disposed of.
Read
my lords, see page 18.
Para 4 at page 18.
My lords.
Today, when the matter is taken up for further hearing, a statement is made by Mr. Chintan Dave, the learned AGP, appearing for the state respondent, that the nodal officer has addressed a letter to the authority in charge of the portal stating that the claim of the writ applicant to carry forward the Sanvit credit is justifiable, and for that purpose the portal be opened to enable the writ applicant to file his Tran 1. Mr. Dave places on record the letter in writing sent to the authority in charge of the portal. The same shall be kept with the record of the portal. People says it is not possible.
Portal people, in fact, I'll point out, the authorities told the portal that we'll be in contempt if we don't.
Let them file a recall application over here. Mr. Seth, did you file a contempt?
Because there, my lords, GSTN was not a party. In that petition, my lords, only the authorities were a party.
Let GSTN be not a party. GSTN is only an extension or a part of the department. It is nothing, something not a complete.
It is a separate
alien to the proceedings. GSTN
it is a government company.
GST department. Just that they are managing the portal. That's all.
It is a government company.
Yes.
Manoj, it is a government company which is and therefore the respondents in that petition, they wrote to GSTN, but GSTN has said that we don't have the procedure prescribed for granting this sort of relief.
The shade GSTN
Manoj
has some problem with regard to portal, correct? Now the only alternative for you is to succeed in that batch of writ applications with respect to Tran 1. If they all succeed,
then that opening part will come up.
Petition automatically succeeds.
But my lords, here, I'm sorry, my lords, here, my lords have already directed them to.
Then go file a contempt.
We have not directed them. We have taken.
They made a statement. I apologize.
Record of the nodal officer, and nodal officer, although he took up the issue with the GSTN, yet it seems GSTN has not been able to resolve the problem. Now, this problem can be resolved only after the final judgment we may pronounce in the batch of writ application.
You want to get it connected with that bunch, we can do that. Otherwise, you go to file a contempt.
Manoj may do that. Manoj may connect it with that.
511 is the
when are those matters coming?
511. I have just issued a message from my colleague. It's 511.
511. We will issue notice and fix 511.
My
lords.
Notice they need it.
Notice they did this. Notice they did.
Look here, we have heard Sri Uchit Seth, Learned Counsel for the petitioner, issue notice fixing 5/11/2020, which is the date on which other matters dealing with the portal of Tran 1 are fixed. List on the said date.
Manoj, may I mention, Manoj, serial number 18, I have instructions to appear in that matter, but my name is also not shown. I don't have the papers.
To inform the court master about that.
It is my appeal. My friend appears for the other side. We are only to request
the
for
court
time.
master of the next date, your name will appear.
We'll request for time.
Manoj, it can be adjourned for some time.
It will be adjourned, don't worry.
Please.
If it reaches, we will adjourn it. If it doesn't reach, otherwise also it will be adjourned.
It's at 18 only, Manoj.
All right.
Please.
Obliged.
How much time do you want in that matter?
1 week will be sufficient, subject to my lord's convenience.
No, you take
anytime. It's a tax
because they
appeal.
are not coming up before Diwali. They'll come after Diwali.
No, that is all. My lords, I have no problem. Obliged.
Mr. Harjot Singh Kaswal. Kaswal.
Good afternoon, Your Lordship. Good afternoon.
Yes. Mr. Kaswal.
Yes, Your Lordship. Your Lordship, in this matter, Your Lordship, the petitioner is Your Lordship, banana exporter. And when he has filed a refund.
Mr. Kaswal, there is an appeal provided, 107.
Yes, Your Lordship. But
prefer a statutory appeal.
But as Your Lordship, I have filed now. I have an order in appeal in that, Your Lordship. I have filed the appeal, Your Lordship, and I have attached at page number. Kindly have a glance at the page number 47. They have rejected that appeal, Your Lordship.
Your appeal is dismissed.
Yes, Your Lordship.
Where is that order? Where is the order?
Your Lordship, page number 47.
Just a minute.
Annexure G, page number 47, Your Lordship. They have rejected this appeal on the same ground as they have rejected the earlier order.
You've heard Shri Harjot Singh Kasawal, learned counsel for the petitioner. Issue notice returnable within 6 weeks. List on the date mentioned in the notice.
Oblige, Your Lordship. Shall I leave, Your Lordship? I am seeking permission from you.
Yes, yes.
Oblige, Your Lordship. Highly oblige.
Yes.
May I, with your Lordship's permission? There are two matters under the Forest Right Act 2006, item number 16 and item number 17. Item number 16 belongs to Dahod district, and item number 17 deals with Chota Utepur district. May I request Lordships to take up item number 17, as I have prepared myself to make submissions into these identical matters at item number 17.
The judgment of this court has not been complied with?
Not at all. More than 7 years have passed. In one matter, 10,000 cases are pending for Chota Udeipur district, and in the second matter, 11,000 matters are pending.
Have you served an advance copy to the office of GP?
Yes, you
have
Mr. Devnani,
my lords.
do you have serial number 16 in hand or 17?
I have both, whatever your lordship, Mr.
You take up 16.
Yes, sir.
And you come to the last page of the judgment. To be precise, page 101.
I'm on page 101, sir.
Now start reading it.
In such circumstances, we would like to dispose of both the petitions by issuing the following directions, which will protect the interest of the claimants as well as the state. The respondents are directed to strictly comply with Rule 13 and amended Rule 12A while disposing of the fresh claims applications or a review application which is already disposed of. In other words, even if a review application has been disposed of, then in such circumstances, the respondent shall reconsider the claim after complying with Rule 13 and Rule 12A of the rules. According to the respondents, there are 128,866 pending claims as on 7/2/2013. We direct that all such claims be decided by strictly complying with Rule 13.
Now you will have to take instructions whether these directions have been abided or not.
I'll certainly, because there is an averment by the petitioner himself on page 21 that the subdivisional committee has in fact rejected around 16,000 on odd cases. Nonetheless, my lords, we'll take certain instructions and I'll revert back to the Honorable Court.
Just 1 minute.
Please.
Take down. We have heard Mr. Anand Yagnik, the learned counsel appearing for the writ applicant. The writ applicant is a registered charitable trust. This trust is rendering its services all across the state of Gujarat, more particularly in the tribal districts, past 3 decades. We take notice of the fact that sometime in the year 2011-12, two writ petitions in public interest were filed seeking appropriate directions with regard to the claims under the bracket Forest Rights Act brackets close and the rules. Full point. Various other reliefs were also prayed for in those public interest petitions. Full point. This court, vide the judgment and order dated 3rd May 2013, disposed of both the writ petitions filed in public interest by issuing the following directions. Page 101, para 45 Lelena, Pura, and 46. We are sad to note that almost 8 years have elapsed. But as pointed out by Mr. Yagnik, there is no further progress in the matter. The directions were issued with a view to see that the interest of the tribals across the state of Gujarat is protected. In such circumstances referred to above, we direct the state government to respond to both these matters filed in public interest by the next date of hearing. Mr. Devnani, the learned AGP, shall take appropriate instructions in the matter and revert to us on the next date of hearing with an appropriate report as regards the compliance of the directions issued by this court as referred to above.
I'm sorry, only if your lordship's permit for a minute, Manoj. But here, in fact, the petitioner himself says that this is the first petition pertains to Sanjeli range. He says that in fact, 16,667 cases are decided.
What's the response, Mr. Devani? What is the problem?
May I?
Your report. File your report.
May I respond to this?
Because it may not. There are no steps taken. That may not be. In fact, that is
his complaint. We are not recording a finding.
Very well. Very well. Please, Manoj.
Mr. Devnani, the rejection of claim has to be approved within a stipulated period of time by the district level committee.
Yes,
the district level committee doesn't meet for more than 5 years. Therefore, the rejections have not been approved. Till rejections are approved, they are not the rejection per se.
Let us wait for the.
I am amazed at the innocence Mr. Devnani expresses with every such matter, in spite of the fact that he is a seasoned advocate as far as the Forest Right Act is concerned.
So Yagnik, he represents the state government.
Yes, but the state through an able lawyer who represents forest right matter again and again and again, and then shows innocuous innocence before your lordships, as if the statement is not to be approved. I'm at pain, Mr. Devnani.
On the point when he said that no steps, I was only trying to assist your lordship that there is some decision which is required to be reconsidered. I have said it is only with a view to see that something is done. It is not as if it is right after the order of.
We have understood that.
Please, ma'am.
Response on the next date we'll consider.
I'm obliged.
Please, lordships. Permission to leave be granted.
Yes. What is the next matter, Mr. Devnani?
तो तूफान हो जाता है देवनानी को
Mr. Yagnik Devnani ko.
But 18 is the matter which Mr. Shade mentioned, Manoj, for next week. Your Lordship said after vacation. Mr. Uchit Seth mentioned at serial number 14. This is
he is appearing for the respondent. Shri Uchit Seth advocate has put in appearance on behalf of the respondents. He prays for and is granted 2 weeks time. 3 weeks time to complete his instructions. Mr. Devnani, you will provide a copy to him?
Yes, sir. It is served, sir. If it is not served, I'll serve it.
Or list after Deepavali vacations, showing the name of Mr. Uchit Seth from the side of respondents.
Please.
Now let us see what Mr. Ankit Shah has to say.
Please, Lordships.
Yes.
This is tax appeal. The question of law is at page 24, Your Lordships. I don't know, there is some technical issue with my camera. It is going off.
Technical issue with your camera.
Yeah, whether the Honorable Tribunal was correct in holding that there was no time limit prescribed for claiming refund of special or additional duty.
Oh, which page are you reading?
I'm sorry, Your Lordship. Page 24, Your Lordships. I thought Your Lordships are at page 24. I'm sorry.
Mr. Shah.
Please, Your Lordships.
For customs, there is nothing like low tax effect.
My lord, in customs, there is no tax. There is nothing like low tax effect. And secondly, this is a case of refund. As far as refund is concerned, wherein government has to give money back to the SSC,
the government is very careful, very cautious.
There is no.
There can be no tax effect there.
To be precise, there was a refund claim of rupees 12,52,000, out of which 7,04,000 was granted. 5,47,000 has been rejected on the ground of limitation. Against that, the present appeal is there. Against 5,47,000.
Not even 7 lakhs.
Not even 7 lakhs. 7 lakh is granted, Your Lordship.
My lord,
that is the question of law, my lord.
What question of law? That cannot be. We want a substantial question of law.
Absolutely substantial. I may assist Your Lordship.
For substantial amount also. Not for a petty amount.
But as far as low tax effect is concerned, in case of refund, it does not apply, Your Lordship. I'll just assist Your Lordship, and I'll leave it to Your Lordship, my lord. I'll just assist. As far as low tax effect is concerned, I will not. But I'll just, without reading the file, I'll just assist Your Lordship. My lord, the case of the SSA is that he has applied for refund he has paid special additional duties of customs. He had applied for refund of 5 different bills of entry, of which total amount of rupees 12 lakh and odd was there. Out of which his few bills of entries were allowed, which were in time, to the amount of rupees 7 lakhs. As far as the bills of entry which he had applied for refund after 1 year.
Mr. Shah,
please, Your Lordship.
Should this court go into all these factual aspects? You come to page 36.
Please, I'll in a moment.
3 paragraphs, 11, 12, and 13, and tell us what is the error apparent on the face of the order. Read it.
No, this is in our favor. Page 11 is in our favor. It is done at tribunal which has reversed this.
Tribunal's order, right?
Starts from page 46.
Please, Your Lordship.
Starts from page 46, right?
Please, Your Lordship. Please, Your Lordship. Page starts from page 46. My lord, what learned tribunal has held that the time of limitation will be.
Just a minute.
I'm sorry, Your Lordship. Your Lordship made it. Paragraph 4, page 48.
So refund claim was of 12 lakhs.
Please, Your Lordships.
The original order awards 7 lakhs.
Please, Your Lordships.
Appeal preferred for 5 lakhs.
Please, Lordships.
Which is allowed.
Please, Lordships.
Okay.
So total refund of 12 lakhs is now to be paid.
Please, Lordships. 7 lakh already paid.
The original authority, why it did not grant the refund for the balance 5 lakhs?
My lord, for the reason that he had made an application for refund beyond 1 year. Beyond 1 year.
Do you leave any amount from being recovered which is
Kuch
nahi. But I'll read the section. Section says that application has to be done within 1 year.
5 judgments have been
relied upon by the tribunal.
5 judgments.
But that is of tribunal. We are relying upon. I will leave, my lord. As far as we are relying upon Bombay High Court, Honorable Bombay High Court judgment, which is. Sorry, Your Lordship.
Depending on the Gujarat High Court.
I leave it, Your Lordship. I leave it, Your Lordship. My lord, may only request is that your lordship may keep the question of law open. Only
there is delay also. No delay.
Delay was there. It was been condoned, and this is coming up for admission after condonation of delay.
All right.
So if your lordship may just keep the question of law open, your lordship.
Question of law open. We can't do that.
We can keep it open provided there is a question of law. What do we keep it open?
Well, in my respect, there is just on low tax effect, as your lordships are saying, I am not pressing much, but otherwise there is a question of law, my lord. That's the only request. Otherwise, my lord, what had happened, this SSC will rely upon this judgment, wherein some huge refund amount is there. That's the only request. Here, the refund amount is 5,50,000 only. There might be a case in the future wherein refund would run into crores. And
Okay, we will observe that, considering the quantum of interest involved. We are not entering into this question.
Please, highly obliged, lordship. Highly obliged. Please, your lordship. Highly obliged. I may leave your lordship with your lordship permission.
Yes, Mr. Patel.
Please, lordship. So the questions are on page F, and outside I must say that identical questions in SSC's own case for the later year has been tax appeal has been admitted.
228.
228, please, lordship. Only additional question, my lord, question C, which is also connected with the first two questions. This may also be considered and admitted along with the two questions. What happens that is the payment of my lord, this associate between the associates company, my lord, royalty was paid, or originally royalty was paid at the 1.5% of the my lord, turnover, and thereafter, my lord, without any justification, it was raised to 3% and 5%.
Have the remaining 4% on account of low tax rate.
It's the main doi.
But he wants the other questions also to be
only one.
Only one of them.
Additional one. This tax.
So all three
of the revenue is admitted on the following questions of law. Good then.
But to be heard with 228.
To be heard with tax appeal number 228 of
2018.
2018. All three are similar?
First and second are similar, 20 and 21. Third one, I need some time because there is another appeal which is not on record, and I also.
No, 21 you have given 234 of 2018.
No, it's the same. Again, 234 is again 228.
That is also to be heard with 228.
Yes, yes, it's a part of a cross appeal and appeal. But that one, they are same. One is by the department, another is by the SSC. That is how.
Same order.
Please. To be heard with 228 and 234. Either.
Now, what is this item number 22?
22, my lord, I need some time because I need to get some instruction from the client independently, my lord. One appeal, 184 of 20.
Made by Shri Varun Patel, Learned Counsel for the appellant, list after Deepavali vacations.
Please, Ashik. My lord, may directly register to place with tax appeal 184 of 20. That's also fresh matter arising out of the same order, my lord, impugned order.
And item number 22.
Yes, my lord.
Appeal number
184 of 2020.
उसमें आगे लिख दीजिएगा अभी जो लिखा है आफ्टर दीपावली वेकेशंस along with tax appeal number 184 of 2020.
Please, oblige. My lord, one more requested appeal. I have a matter at serial number 40. Well, earlier, it's a fresh matter. Here also, my lord, identical appeal in SSC's own case has been admitted. It will not take more than 1 or 2 minutes. If it can be taken up, serial number 40.
Will be 40. What is the number of the appeal which is admitted?
That appeal is about tax appeal 116 of 220.
116.
16.
116.
Please, Lordships.
An order passed on?
It's an order passed on 2nd March 2020. I have said so in page C.
Oh, that professional conduct.
Yes, my lord. That distribution of my lord gifts to the doctors, which is completely illegal as per the.
This is the only question proposed in this appeal.
Yes, it's the only question. It's only question. Page D is the.
And to be heard with tax appeal number 116 of 2020.
Please, Lordships. Deeply obliged. Obliged. May I?
Please, madam.
Sorry, Manoj, I was not here when.
Yes.
Sorry, Manoj, I was not here when they.
No, that's all right. Busy council can't be everywhere all the time. Huh?
Lordships, one small request, my lords. Mr. Vipin Upadhyay, my lords, he is another advocate appearing with us. If my lords may permit him into the room.
Now, who appears for the respondent in this matter?
This is a fresh matter.
Notices have not been issued or copy has not been served.
Yeah, it's a fresh matter. Union of India, Manoj. Copies are not served, and this is a matter coming up for the first.
Bataiye. Yes.
Here, Manoj, the issue is, Manoj, that the petitioner is seeking to correct the bills of entry which it had submitted earlier, so as to avail of the beneficial entry as far as the rate of duty is concerned. This is permitted according to the petitioner under section 149 of the Customs Act.
Yes.
When the petitioner made an application for the first time, it got rejected without even giving an opportunity of hearing to the petitioner, stating that it was after the event and therefore delayed, and therefore for that reason the application was rejected. We challenged it through the regular route, where finally we succeeded that you need to at least hear them before you pass any order. So the application goes back. So the order was set aside. The application for the section 149 correction goes back to the authority, who states that, who again rejects it and reiterates what was said in the order which has already been set aside by the appellate authority. Is why we have moved here without going through the regular gamut of the appeal is that the reasons which he has given are directly contrary to the Honorable Supreme Court judgment which was cited before it. So, Manoj, should I just indicate what before I take your lordships to? Manoj,
Section 154 was relied upon by you, KD.
149 and 154 both.
You relied upon?
Yes.
If you rely upon 149, why do you go to 154?
No need, it is an alternative. Your lordships are absolutely right.
No, Mr. Joshi, they are poles apart.
Yes,
154 talks about correction of clerical errors. There was no error at your instance.
No, so the background, I'll just give your lordships the background. What had happened was, my lord, that there were two entries.
Just a minute for our understanding.
Yes.
You are relying.
Just
a minute. You are relying on section 149. Correct? Amendment of
Yes,
document.
should I join again? I think my connection is. Am I audible to your lordship?
Yes, yes, very much.
You
We
are
can hear
audible.
you.
Are we audible to you?
It is breaking up. Now your lordships are audible. Sorry.
You are invoking section 149.
Yes, ma'am. That's right.
Will you not be hit by the proviso?
That your lordships may kindly see 149.
Page 37 of your paper book.
I got it, ma'am. Provided that your lordships are on proviso.
Yes, proviso.
Provided that no amendment of a bill of entry or a shipping bill or a bill of export shall be so authorized to be amended after the imported goods have been cleared for home consumption or deposited in a warehouse or the export goods have been exported, except on the basis of documentary evidence which was in existence at the time the goods were cleared, deposited or exported as the case may be. I am not adding a single document.
Now you are seeking amendment in the bills of entry.
I am seeking amendment in the bill of entry.
What is the nature of amendment?
Yes, so should I not just take now? I'll just give 3 or 4 dates, so that the mobile phones in question were imported from May 14 to July 14. At that time, do your lordships also have the compilation in hand?
Yes.
If your lordships have the compilation, I imported the goods from May 14 to July 14.
Yes.
There is no dispute about the tariff classification, etc. In the compilation which I have given to your lordships, please see item 2, page 13, 1-3.
Yes.
It starts at 14.
The notification.
The notification. Now this notification is relevant because when I import the goods, in addition to customs duty, I have to pay additional duty under the Customs Tariff Act, which is equivalent to the excise duty leviable on a like product in India. I have to pay customs duty and also additional duty under section 3, etc. of the Customs Tariff Act, which is equivalent to the excise duty. Nothing turns on it, my lord. This is just, so now your lordships may see this. The next page at page 15, 263A.
Yes, stop.
It
Mobile
said this at the top.
Yes.
Your lordships will find 8517 mobile handsets including cellular phones 6%. Your lordships find that?
Yes.
And mobile handsets including cellular phones 1% subject to 16, condition 16. The last column, 16.
Yes.
Just parallel to that, 16 is on page 17, 17.
Now, what is the basic difference between Roman 1 and Roman 2 here?
Roman 1 and Roman 2 is that if you comply with condition 16,
Then
you are
the
entitled to
1%.
lesser duty. It is 6% otherwise.
Now, what is condition 16?
Condition 16 is at page 17.
17.
17 of the same notification at the bottom last line. If no credit under Rule 3 or Rule 13 of the SENVAT Credit Rules 2004 has been taken in respect of the inputs or capital goods used in the manufacture of these goods.
We have heard Shri Mihir Joshi, learned senior advocate, assisted by Shri Parth, contractor, and Shri Vipin Upadhyay, learned counsels for the petitioner. Issue notice returnable within 6 weeks. List on the date mentioned in the notice.
Lordship.
Yes.
You don't want any interim relief, Mr. Joshi?
No.
Obliged.
Yes.
Obliged.
Now we come to item number 23.
These are those ad hoc appointees seeking benefit of pre-2008 benefits from a particular date.
Today, what are these matters listed for?
These are at the stage of delay.
Delay.
Similar matters, if your lordships recollect, were argued by the learned government pleader, opposed by the my friends here in Lords. Replies were filed, but your lordships have reserved orders as far as those civil applications are concerned. Lords, subject to what my friends have to say, the same contentions they have raised. One, that there is no sanction of the legal department, which again factually I'll be able to point out from the pleadings hearing that the legal accorded permission.
So we reserve orders in these also similar on delay.
And not subject to what my
Anyway, as far as these matters are concerned, we have not that we are urging that it should be decided on merits. Honorable Court may go on merits. For formality, reply has been filed. As because Honorable Court said that by that time, if you want to file the reply, you can file the reply, and we have filed our reply.
Not direct you to file reply. You wanted to file reply, therefore we granted you time. Correct?
Please oblige me. Oblige me.
Either you say that you are not opposing.
The matters are concerned, my lord. The matters.
1 minute. Either you are opposing or you are not opposing.
My lord, may argue on merits. That only I am saying.
No. Merits will come after the delay application is either condoned or rejected. If it is rejected, the appeal also consequentially is dismissed. If the delay condonation is allowed, then the question of hearing the appeal will come. So either you are opposing the delay condonation application or you are not opposing the delay condonation application. Because if you are opposing, then we have to pass an order. Either we condone or we do not condone after hearing your objections and everything. But if you are not opposing, then we can say that you are not opposing and therefore we condone the delay.
Formally, I am opposing the delay condonation application, my lord, because the application, as far as the judgments, all the judgments which are being passed by the Honorable Single Judge are passed, my lords, in the year 2019, either in June, July, in that month, my lord. More than 1 year has been passed.
Simply asking you one question: are you opposing the condonation application or you are not opposing?
Lord, even Lordship may fix the main matter for hearing. That would be
all right.
My friend will have to say that whether he is allowed to. Please.
We take it that you are not opposing delay condonation. We condone the delay and list the appeal for admission. Correct?
He fix the appeal for admission. Please, my
lord.
Yes. We have heard Shri D.M. Devnani, learned AGP for the state appellant, and Shri Krama Qureshi, learned counsel appearing for the private respondent. In 1, 2, 3, 4. There are 5 matters today.
5 and 1 is serial number 2.
Lord, one matter is of my learned friend, Sri Soni. Perhaps he is there or not, I don't know.
Mr. Soni is there.
Lordship.
Mr. Nicole Soni. Now, just 1 minute. So, there is one matter from Per Court Board.
Yes, my lord.
That is civil application 2387.
Please.
Please. Then Mr. Qureshi appears in 2106.
Yes, my lord.
Then further Mr. Qureshi appears in
199. Yes, my lord.
And 2012.
Yes, please.
So 4 matters of Mr. Qureshi and 1 matter of Mr. Nicole Soni. That is
please
1767.
May I request, my lord?
Yes.
I have filed my reply opposing delay. And there I am relying upon the judgment of Honorable Apex Court.
Very well.
206 days of delay, and I rely upon paragraph 13 of that judgment.
Seriously. So Mr. Soni, are you opposing the delay condonation application?
Please. I have placed the judgment on record.
वो भी करा. Justice Sanjay Kishan calls judgment.
No. It is of living media. Postmaster General versus living media.
अरे वो तो बहुत पुराना हो गया.
अभी नया आ गया.
Latest I have not taken.
आ गया है.
Please.
हाँ. अभी अगले हफ्ते तैयारी करके आइए फिर ठीक से बहस करिए इसको.
Please, because I have already filed the reply. I have not placed that.
All right. So, now today, Mr. Ikrama Qureshi says that he is not opposing the delay condonation. So, we can, in his appeals, we can condone the delay and list the appeal for admission.
My lord.
In your matter, we will have to decide your delay condonation application.
Please, my lord. Because I have filed reply.
No, Mr. Qureshi also filed reply, but he said it's only formal. I am not opposing the delay. Filing of a reply is a requirement in law.
Then
But
I leave it to my.
actually, what you are doing is something different.
Then I leave it to my lord because I have filed reply in the main appeal also, opposing appeal to on merits.
All right. Now listen to the order.
Please.
We have heard Shri Dharmesh Devnani, learned AGP for the state appellant in all the above 5 applications. पांचों का कॉमन ऑर्डर बनेगा. कॉमा लिखिए उसके बाद श्री इकरामा कुरैशी, learned counsel appearing for the private respondents in CA number 2106 of 2020, 1996 of 2020, 2012 of 2020, and 2387 of 2020. And Shri Nikul Soni, learned counsel appearing for the respondent in CA 1767 of 2020. Except for CA 2387 of 2020, Mr. Qureshi, have you filed your? नहीं इसमें नहीं है. Except for CA 2387 of 2020, in all 4 other matters, learned counsels for the respondents have filed their objections / counter affidavit in the delay condonation matter. ठीक? Full stop. However, while making their submissions, learned counsels for the respondents, Shri Ikrama Qureshi and Shri Nikul Soni, submitted that they are not seriously objecting to the condonation of delay. Full stop. Next paragraph. Having produced the explanation tendered by the state in support of the stated in the affidavit filed in support of the delay condonation application, we find that the same has been satisfactorily explained. Accordingly, in view of the above, we condone the delay in all the applications. We condone the delay in filing the appeal and allow all the 5 applications. Okay? Full stop. Office to register the appeal on the regular site and list them again for admission in the week commencing 23rd November 2020. ये 5 मैटर्स का एक साथ कॉमन ऑर्डर बनाइए. No, he gave it. What strong किया है? Government is going to be in problem, but they did not oppose it. What to do? कॉस्ट भी लगाया स्टेट ऑफ मध्य प्रदेश. Next matter, what is this, Mr. Government AGP?
But 24 again is the same matter of arising out of the same group, pre-2000, rather post-2008 appointees, and
now this is for the first time it has come.
Then your lordship may kindly issue notice. I'll see to it. Please notice.
No one is appearing in this. You are not appearing.
If I can know the name of that petitioner, perhaps I may have instruction.
Sonal Trambak Dave.
My lord, sorry.
Sonal
Champaklal Dave. No, my lord.
Trambak Dave.
No, my lord. My lord, we have permission to leave.
Yes.
Please.
इसमें 2149 लिखिएगा. Heard Shri Dharmesh Devnani, learned counsel for the AGP for the state appellant, issue notice on the delay condonation application. केवल डिले पे इसमें इशू नोटिस करिएगा, अभी अपील में मत करिएगा.
I'm obliged, sir. I'm highly obliged.
Mr. Udit Vyas.
My Lords, may kindly permit Mr. Dhaval Dave, Senior Advocate. He will be appearing for me in the matter. He is also in the waiting room, my Lord.
All right.
Obliged, man.
Right to information.
Yes, Mr. Dave.
Petitioners appeal number 1 and 2 both are the companies. The petitioner number 2 is a subsidiary of petitioner number 1. So they have been held to be amenable to the Right to Information Act on the ground that they are public authorities. Now, finding recorded on page Z32 of the impugned judgment and order, paragraph 13, on the premise that they are substantially financed by the state government. There was nothing on the record, no discussion how they are substantially financed. Would my lords turn to paragraph 13 on page Z32 first? Page Z32, impugned judgment, paragraph 13, where the conclusion is recorded by the learned single judge.
Page Z32.
Z32, paragraph 13, 1-3. The internal page 39 of the judgment, last page of the judgment.
Yes.
Under such circumstances, applying the ratio of the apex court to the facts of the case, it is not possible to hold that the petitioners who are substantially financed by the companies owned by the state government cannot be said to be public authority, and as such the petitioner will be covered by the definition of public authority under section 2HDI of the Act 2005. Now the reasoning would start from paragraph 7 on page Z.
1 minute, 1 minute.
Give us some background of your company. What is your company doing?
We are into venture financing.
Beg your pardon?
Venture financing, Manoj. No, we finance new ventures. No, Manoj, this company.
Who went before the commissioner, RTI?
That's
resignation.
Number 1.
Arvind Bhai Sanghi.
Who is he?
He is the person seeking information with regard to some company in Chennai to which we are given a finance long back, Manoj. And Manoj, in my respectful submission, we do not have any governmental assistance in any form. No, only the government companies.
Body owned, controlled, or substantially financed?
Yes.
Non-government organization.
Substantially. They would be covered.
Huh?
How do you say you are not covered, Mr. Dave?
I am not receiving any financial aid from the government. When Honorable Supreme Court has interpreted was substantially to mean that you must depend upon government fund for your existence. So today, in my research,
not receiving any fund from the government?
Oh my lord, we were only one of the government companies was instrumental in setting up this company. So thereafter, we have not received any financial assistance.
You are like a state finance corporation, something like a state finance corporation?
In my respectful submission, one of the government companies, that is Gujarat Industrial Development Corporation, that was instrumental in promoting this company. Thereafter, in my respectful submission, we are not substantially financed. Nothing recorded.
You are Gujarat Venture
Finance Limited.
Limited. Now you are financing ventures, new ventures, old ventures, pending ventures, dying ventures. You are reviving them, doing whatever, right? You are financing. You are providing finance.
Company, any other company, ma'am.
Other companies.
But we are not amenable to any government finance.
Mr. Dave, come to page 3 of your petition and let's see the question of law which has been framed by you. can a company
Neither
which is
owned.
neither owned nor controlled nor substantially financed directly or indirectly by the funds provided by the state government or the central government be construed as a public authority within a meaning of Section 2H of the Right to Information Act on, now this is important, on the solitary premise that several other companies, the equity shares of which are substantially held by the state government, have subscribed to the equity share capital of such a company, and further that the chairman of such a company is the managing director of a fully owned government company on account of provision in this regard made in the articles of association of such a company. The managing director also appears to be your managing director.
My managing director is professionally appointed. The chairman of this company is the managing director. There is a provision in the articles of association. The chairman of this company will be ex officio member. He will be that Honorable Supreme Court has an occasion to interpret this clause in the judgment of my Lord Tharapans Cooperative Society Limited, 2013-16 SCC. 2013-16 SCC. The Supreme Court says substantially means complete control, complete finance.
If you are financing, then all the more you need to be transparent in your working. Why are you shying away from providing information?
Look, we are worried about some person for seeking fishing inquiry. So this fellow has nothing to do with
fishing inquiry. Whatever record you have, you provide the information.
Also, in my under the Companies Act, I have to submit all my returns. So in my respectful submission, if I am not falling under the purview of Right to Information Act, nobody has a right to invoke the application thereof. So Lande Singh has with profound respect. Records that I am substantially financed are a single finding. No discussion how I am substantially financed. Paragraph 7 onwards, page Z24, the discussion starts, reasoning starts. I will sit down, there is single sentence as to how.
Take us to the order of the authority under the RTI page.
Yes, ma'am. That level would be on page 202. I'll just point out.
It starts from page?
It starts from page 1.
Huh?
Just a moment. Relevant will be on page 200 on this aspect.
No.
It starts from.
That's from which page?
195. 190.
195. Okay. Now,
only one.
The commission has carefully gone through the argument of the complainant. Respondent so-and-so is renamed as so-and-so. This is only a change of name, and the present GVFL is a successor of Gujarat Venture Finance Limited. Therefore, the commission treats the application of complainant so-and-so as complaint under the Act against GVFL Limited. The commission has heard the complaint, respond, gone through this. Commission refers to the so-and-so, so-and-so, make a reference, so-and-so.
That is regarding composition number 2 company as a subsidiary company. To which no notice was issued at any point of time. Straightway it was held to be. The reasoning, my lords, will find in paragraph 7, page 200 on substantially financed part. Only share capital by one of the companies. Now that is not a substantially financed. The one may contribute to the share capital. The point is whether day-to-day financing is there or not. The paragraph 7 on page 200. That's the only, and Honorable Supreme Court says that what is the meaning of substantially financed? That you must depend upon government fund for your existence. So we have given facts and figures.
If you get out of the purview of public authority, you are not obliged to provide the information.
Only under the Companies Act, one can visit company, register of company's website, and whatever information required under the Companies Act, they can. Otherwise not. So today, otherwise, in my respectful submission, if this is construed, then each and every company where government subsidiary share capital will become the public authority. But that's not the object. The object is an Honorable Supreme Court is an identical situation.
Public authority and public functions. Is it necessary that it being a public authority, it performs public functions?
Will not be. In my respectful submission, if you are a public authority, there is no concept of you being performing public function under RTI. It simply says, and therefore a definition. If you are falling within the purview of that, for example, non-government organization, if it is may not be discharging a public function, but you substantially financed.
Substantially financed by GIAC, which is a 100% company.
Gujarat
Industrial Investment Company. What is GIIC?
The GIIC is a company which has only contributed at the point of time when the company was formed by subsidiary share capital. It's a government company. So thereafter, it has no role to play in my day-to-day functioning. Honorable Court has not held. Nani Singhal is not. I am directly controlled by the government company. They substantially financed. Only thing which is found against me by London single judge.
The question I was putting to you earlier, that you are Gujarat Venture Finance Limited, GVFL, correct? Now, where do you get the funds to so that you provide finance to ventures?
Well, I generate my own funds in my respectful submission, and therefore my
Are you a public limited company or a private limited company?
Public limited company.
Public limited company. You are a company held by shares and debentures.
And today,
why you listed a public authority?
Why I am a public authority? Because each and every public limited company cannot be the public authority. A company which depends substantially for the finance. Substantially finance, the Honorable Supreme Court has interpreted to mean you must depend upon government funds for your existence.
Now, your argument seems to be that at the inception, EIIC financed this GVFL.
What finance? I'm sorry, not finance.
Then
subscribe to the share capital to the extent of 39%.
They are still holding that share of 39%.
Then straight. And one of the Supreme Court says, no, let us see how statutory finance has been interpreted. It is a direct judgment. Cooperative society, for example,
substantially would not mean majority or 51% stake. No, substantially would be 39% is a substantial amount of total subscription.
The Honorable Supreme Court says substantially means you must depend upon government fund for your existence.
Today, if they withdraw this 39%,
I can survive. 60, more than 65% by others. Only 39%. Today, in my respect, and secondly, share capital is a different concept.
Very fact.
I give the finance.
You cannot use the name of the state unless you are a part of
मेरे
the
हिसाब
state.
से तो public.
Therefore, in an identical fact situation, the Honorable Supreme Court interpreted the term substantially financed.
In which case?
Well, in the case reported in 2013, 16 SCC page 82.
Thalapalvam Service Cooperative Bank Limited.
Yes, same. My lord may turn to paragraph 46. Paragraph 46.
46.
Yes, on page 107.
Yes.
The words substantially financed have been used in section 2HD, clauses 1 and 2, and while defining the expression public authority.
1 minute, Mr. Dave. Mr. Dave?
Yes.
Now, on your board of directors, are there government nominees?
In my respectful submission, chairman is a government nominee.
And?
Mike Malad, the Articles of Association, we have to elect the board of, well, there could be. My submission is, but I have not been held to be controlled by the government. Even though today majority is, I am held. London single judge has not held me as controlled by the government. But there are 3 different expressions used under the Act. You are substantially controlled.
The prefix which has been used is or. First thing, it is an inclusive definition. Public authority, forget about A, B, C, D, and includes any body owned, controlled, or substantially financed, directly or indirectly by funds provided by the appropriate government. Body owned, controlled, or substantially financed. I would not fall within the ambit of controlled.
London single judge, in my respectful submission, has not held me as public authority on the ground that I am substantially controlled, nor even the authority commission model. I have been held to be only on the ground of substantially financed.
Learned single judge proceeds on substantially financed.
So also commissioner model, public information commissioner.
Correct. Now let us test your argument.
Please.
Your argument is that we were not financed by GIIC, but at the time of inception, when this company was floated, 39% of equity shares were purchased by state government. State government, right?
No, a company owned by the state government.
Company owned by the state government.
That is GIIC.
Right. Now, holding this particular stake, that means that, let us say 39% of shares as on date are held by that company owned by the state, correct? Will it not amount to investment?
In my respectful submission, it amount to investment, but it would not amount to substantially financing the company. The term substantially financing has been
investment is for what purpose? Not for substantial finance?
In my respectful submission, for raising the share capital of the company, for bringing the company into existence. So Honorable Supreme Court says, substantially finance means finance of such a nature for the want of which the company cannot survive. Now, I have given facts and figures of recent. In 2018-19, my expenditure is 5 crores. Another example, my lord. Sorry.
Mr. Devnani,
Please, my lords.
you appear for the State Information Commission?
There would be a panel, I believe.
Huh?
There would be a panel, I believe, sir.
Yes, panel of
There would be a panel, my lords.
There would be a panel.
My lords.
And who was appearing for Arvind Bhai Singhi?
Lord, there's some
Private. The main
advocate had appeared. Mr. Kotwal had appeared. People under signature. Mr. Kotwal.
Mr. Om Kotwal.
Yes, he had appeared before under signature.
And Mr. Shivang Shah appeared for the commission.
Commission here. Basically, the quasi-judicial authority.
Yes, Mr. Dave.
Paragraph 46 of the judgment of the Honorable Supreme Court upon which I was placing the line. The word substantially finance have been used in section 2HE 1 and 2 while defining the expression public authority as well as in section 2A of the Act while defining the appropriate government. A body can be substantially financed directly or indirectly by funds provided by the appropriate government. The expression substantially financed as such has not been defined under the Act. Substantial means in a substantial manner so as to be substantial. In so and so words, while interpreting the provision of section 10 of the Land Act 10 and Mortgage Interest Restrictions Act 1920, the House of Lords held that substantial is not seen as not unsubstantial. That is just enough to avoid de minimis principle. The word substantial literally means solid, massive, etc. The legislature has used the expression substantially financed in section 2HD 1 and 2, indicating that the degree of financing must be actual, existing, positive, and real to a substantial extent, not moderate ordinary or tolerable, etc. We have often used the expression question of law and substantial question of law and explained that any question of law affecting the right of parties would not by itself a substantial question of law. In Black Dictionary, then Malord.
Yes, Mr. Dave.
Thereafter, paragraph 48, and this judgment has been considered recently also in 2019, and wherein an example has been given which appropriately applies to my case before the paragraph 48 of this judgment of 2013, merely providing subsidies. I'm sorry.
Yes, yes.
Paragraph 48.
What is it?
Merely providing subsidies, grants, exemptions, privileges, etc. as such cannot be said to be providing funding to a substantial extent unless the record shows that the funding was so substantial to the body which practically runs by such funding, and but for such funding, it would struggle to exist. Proposing for a moment with my Lord's permission. Where is the data discussed on this count in the impugned judgment? Putting a question to myself with profound respect. Where is the finding recorded, either by the commission?
Data, the single judge does not seem to have proceeded on data. Single judge seems to have proceeded on the footing that the state government has subscribed to 39% of your equity shares. At the time when you came out with the...
Cannot be said to be a sub.
And today they are holding it.
With profound respect, that cannot be said.
And the managing director of your company is also...
Not managing director, is professionally appointed. Chairman, when a board meeting comes, the annual general meeting is there, chairman's role will come. In my respectful submission, this is just to... There are so many companies, nominee directors as government officers. Just to see that in the public, the image of the company is enhanced, but this procedure is followed. Plus, Honorable Supreme Court clearly says that merely financing is not sufficient. And in paragraph 48, example has been given of a NABARD. Lordship is going to compare that example with the facts of Mike. Paragraph 48. And the first case is, I must struggle to exist. I have given data, my annual expenditure is 5 crores as against share capital of 1 crore, out of which 39 lakhs contributed by one company share capital. Every year more than
you are the state's baby.
No,
you are created by the state. Listen, all your directors, first directors were state government nominees and state government employees.
I am immensely obliged.
After that, you want to disown your parents. This is a very bad, I think a bad example.
Immensely obliged. The Honorable Supreme Court said that merely because state was instrumental in giving birth to you, it cannot be termed as a public.
Giving birth is different, but here they have created you. Yes.
No, again, in the board of the independent board, there are so many companies. That's the example given of Nawaz. Lordship may see paragraph 48 further of this judgment. Further example has been given. First case is, I must vanish, but for the day-to-day funding of the government. Now, after my inception long back in 2002 or 3,
you tell us who is your promoter.
One of the promoters. Because one of the
who are your promoters? All right, let's see.
One of the promoters is the
how much share capital your directors have brought in?
39%. Thereafter, there is no contribution from that.
It's all public money. Otherwise, 39% the state government's fund on the basis of which you were born. Without it, you are not even born.
It is not substantial. Substantial has been defined therefore. Similar example has been given in paragraph 48. If my Lord permit me to read further, the state may float many schemes, generally for the betterment and welfare of the cooperative sector, like deposit guarantee scheme for assistance of NABARD.
Wait. I said okay. All right, we will decide this question. We are fixing 25th of November. Come prepared with everything, whatever brief notes or brief submissions you want to submit, you submit. And we are issuing notice for that date.
Well, Lordship may give me the liberty to place on record the relevant financial data which will be assisting my Lord additionally because of petition is about the early year 2009 or 10. Thereafter, we can put on record, we have given you.
Dhaval Dave, learned senior advocate, assisted by Shri Udit Vyas, learned counsel for the appellant. Full stop. Issue notice returnable on 25th November 2020. It is made clear that the matter would be finally heard on the said date. Full stop. In the meantime, learned counsel for the parties would be free to file any additional material as they may deem fit.
Means in the meantime, stay of the judgment. Otherwise,
what?
Stay of the judgment of the single judgment.
No. 25th November, we are deciding it finally.
It operates against me. Therefore, today,
what will happen? You don't comply, they'll file a contempt. What more they will do?
So they will not bother to seek information thereafter.
You don't provide the information, you hold back.
Please,
see what happens in the next date. At your own risk, not at the risk of the court. All right?
Number two, be interested also. Because fishing at that point of time. Except number two, nobody else will ever
doing it at your own risk, not at the court's.
Absolutely. I will have to trouble your lawsuit by moving an application if you come.
You are free to move application in case something happens.
Please, lawsuit.
Right. Thank you.
Immensely. May we listen?
Yes.
Immensely.
So now your friend is coming.
एकदम बोगस मैटर के साथ
वो अब आते ही बोलेगा. Yes, Mr. Majmudar, this side, not that side.
Yeah, please, your lordships, I apologize. Now here, 42 years delay is condoned by the Honorable Revenue Tribunal. Here, there is some substance in my matter, not like other previous matters, with all fairness. If lordships are believing my submission that there is no substance, then in the same manner I am really submitting. Kindly see the...
Mr. Majmudar, law is well settled. Where an authority or a court has exercised its discretion in favor of hearing on merits, then the extraordinary jurisdiction should not be invoked. If the tribunal has condoned the delay, then let the matter be thrashed out on merits.
But kindly see, there is no reason they have not stated 42 years. Their application may kindly be seen, page number 55. I have been held as a tenant in 1976 and my brother had never challenged my status as a tenant till he survived. He passed away in 2004 and widow files application in 2019, page 55. This is the only delay ground.
Mr. Majmudar, what do you propose to challenge before the Revenue Tribunal?
The order of the Honorable Tribunal.
Respondents.
Yes, order of...
The respondents, the opposite party, what do they propose to question before the Revenue Tribunal? What is the nature of that order?
Yes, 1976 tenancy order by which the present appellant was held as a tenant. Certificate under 32M was ordered to be granted by the concerned authorities. That came to be confirmed, and the subject matter land was held as a tenant by the appellant. The widow, one of the brother of the appellant, in fact, it had gone to his share. Partition took place in 1956, but land was cultivated by the appellant.
The respondents are the original landowners?
The original landowner was a father of the appellant as well as the father-in-law of the petitioner before the tribunal.
How can a relative of the landowner claim tenancy rights in the property?
Because the reason is this is that this land...
I vividly remember some provision in the Act by virtue of if he is related, if a person claims tenancy right and that person is related directly to the landlord, can he claim tenancy rights?
In fact, but
Your client is brother of original landowner, right?
part of the land had gone to the share of my another brother, and I am claiming tenancy of my brother way back in 76. Those proceedings.
Does the law permit you to claim tenancy rights to your brother? If your brother is the landlord, can a brother say that I am a tenant cultivating the land?
वो brother was staying in US. उन्होंने करना पड़ गया उसको मालूम पड़ा.
Check up the provisions in the act.
Can I check it up and can I get back to you only by Monday?
Yunani?
I check the law on this point. I will fairly consider.
Just give me a minute, Manoj. I'll immediately point out.
You just tell us whether a person claiming tenancy rights, if he happens to be
related,
blood relations
to the landowner,
can he claim tenancy rights?
There is a provision. Just give me a minute, Manoj. I'll immediately.
Please tell us. Good. Tenancy Act. Law.
Mr. Majmudar, your clients are not honest. You would be knowing that. They cheated their own family members. Correct? Yes. No, you are a fair counsel. Say yes or no. Don't say it's all right. Otherwise, your client will hear you.
In fact,
so let it be.
Before my lords, I will never say lie.
I know that. Therefore, I ask you very
lordships. In fact, but he took, apart from law, his father, my client's father, in fact, favored my client, and another brother was shareholder, but my client was held as a tenant in 76. I am only on the delay part, your lordships. Fairly submitting, I can't be unfair before anyone, before honorable court, your lords. My lords are.
Let the matter be thrashed out on merits.
Yes, sir.
Right?
Yes, sir.
Okay.
Only one thing, observations may not come in the way because honorable tribunal has controlled.
We will not make any observation on merits. We will not make any
but honorable tribunal has made observations on merits and condoned the delay and admitted the revision.
Mr. Majmudar, learned single judge has taken care of this particular aspect which you are arguing. Single judge says only for the purpose of trying to explain the delay that I have gone a bit into the merits of the matter as to what transpired during the course of last 42 years. Otherwise, single judge has not expressed any opinion whether you are a lawful tenant or not.
He is worried about the tribunal's observation.
Tribunal's observation. I will have to go before the honorable tribunal for merits for final hearing, and entire order of the honorable tribunal is on merits.
No. Now, just 1 minute. The revision before the tribunal, the only delay condonation application has been allowed against which you have come to the High Court, right?
Yeah, delay condonation was allowed on merits and admission order of the revision, your lordship.
Now the revision is to be decided on merits, correct?
Lordship.
Very good.
So that observations of the honorable tribunal may not be, it may not come in my way.
Once the tribunal itself is going to hear it on merits, it will examine everything. The condonation application chapter closed. That was a stage of a interim stage of a delay condonation application. Okay.
Lordships may kindly make suitable observations so that at least tribunal may not be influenced by Lordships.
By his own
And
order. All right.
And some expeditious hearing of the proceedings, Lordship.
We have heard Sri N.K. Majmudar, learned counsel for the appellate. Full stop.
Section 4, your lordship, may kindly.
4, yes. Read it.
A person lawfully cultivating any land belonging to another person shall be deemed to be a tenant if such land is not cultivated personally by the person and if such person is not.
Section 4.
Ji, sir. Person to be deemed tenants.
Oh, sorry. Sorry. It may come handy some another matter.
Yes.
In fact, there is a judgment of your lordships on the same issue, but then I'll...
A relative cannot.
Yes, section...
To be deemed tenants.
Not a member of owner's family.
And this person is not member of the owner's family.
Owner's family.
लिखिए we have heard Shri N.K. Majmudar, learned counsel for the appellant, and Shri Dharmesh Devnani, learned AGP for the state respondents. Full stop. The learned single judge dismissed the petition of the present appellant, confirming the order of the Gujarat Revenue Tribunal, whereby it had condoned the delay in filing the revision. Full stop. The effect of the said order is that the revision is now to be heard on merits. Full stop. Learned counsel for the appellant Shri Majmudar has vehemently submitted that the tribunal, as also the learned single judge, erred in condoning a substantial delay of 42 years, which otherwise could not have been condoned ordinarily could not have been condoned, for no reasonable and satisfactory explanation. Full stop. He therefore submits that both the order of the tribunal condoning the delay, as also that of the learned single judge, suffer from serious infirmity. Full stop. Next paragraph. In our considered opinion, where a revisional authority has exercised discretion in condoning delay and further directing that the matter be thrashed out on merits, no interference in extraordinary jurisdiction ought to have been made out, and therefore the learned single judge rightly dismissed the writ petition. Full stop. We thus do not find any manifest error of law or perversity in the order of the learned single judge warranting interference in appeal. Shri Majmudar, learned counsel for the appellant, then submitted that certain observations made by the Gujarat Revenue Tribunal on merits of the matter while dealing with the delay condonation application may come in the way of the disposal of the revision on merits, and as such the same may be, and as such necessary observations may be made so that the revision may be heard on its own merits, uninfluenced by any observations made by the Gujarat Revenue Tribunal while allowing the delay condonation application. Full stop. Such request made by Sri Majmudar, although otherwise not legally sustainable, but still we make it clear that the Gujarat Revenue Tribunal, while dealing with the revision on merits, will not be influenced by any observations that may have been made on the merits of the matter by deciding the delay condonation application. Okay. With the aforesaid observations, the appeal, being bereft of merits, is accordingly dismissed.
Lordship. Now, as Lordship said, ask me question whether your client is honest or dishonest. Now, order is passed. I advised him that your brother's widow, you should not made her to go to the court of law. You should have sorted out. This is why fairly. In fact, I told him कि आपको जो happily आप divide करो उनको जो
कि आप तैयारी रखिए ट्राइब्यूनल का ऑर्डर मैरिज पे चैलेंज करने के लिए।
लेकिन अभी मैं कहता हूँ I advise when he said के
one more thing let us tell you, you are now on YouTube, your client might be watching, so don't make any kind of observations, refrain yourself.
But this is after an order. This is my opinion, which I expressed when he came to me for the first time. I should be very honest with the honorable court. I didn't accept readily the matter.
That is the spirit I like about you, huh? Yes, thank you.
Oblige your lordship. May I take leave, your lordship?
Yes, yes, yes.
Oblige your lordship.
गैस वाले बैटरी में क्या हुआ? एडजस्ट कर दिया हम लोगों इसको डबल दवाई वाला में तो राइट नोटिस निकाला अभी सर 27 एक और लेने
मुंशा आएगा सर और वो मिश्रा भी आएगा
हाँ नहीं मुकेश मिश्रा इज देयर इट इज मुंशा हेमंत मुंशा सर मुकेश मिश्रा को ये देखिए बैकग्राउंड कहीं वहाँ बैठा हुआ कोर्ट कोर्ट में Yes.
Yes, my lord. My lord, may I say one thing at the outset, my lord?
Yes.
My lord, there were two petitions decided together. My lord may turn to page H. My lord, 20894 of 2017.
Yes.
Special say 20894 of 2017. Another one is special say 21570 of 2017.
Yes.
Page H, my lord.
Yes.
My lord, present LPA before my lords, that means LPA number 722 of 2020 is against 21570 of 2017.
Yes.
So far as special say 20894 of 2017 is concerned, my lord, honorable court was approached by way of filing latest patent appeal number 663 of 2020, and my lords have issued notice on 7th of October 2020, and stay order is also granted on 7th October 2020. So
Where is that order?
Yes, my lord. I request that both the matters be kept together. No, my lord, I have serious objection. My lordship has not disclosed the entire facts before your lordship. My lord, no, but allow me to, firstly, if you say that I have not disclosed, then allow me to disclose. Yes, sir. Yes. I'll do the matter. Lord.
Yes.
So, my lord, that is LPA 660 of 2000.
Mr. Munsha, what objection do you have with regard to continuity of service?
Lord, there are two objections, my lord.
Yes, what is the first objection?
Yes, my lord, I am obliged, my lord. Firstly, my lord, he served as daily wager between 21st May 1986 to 7th January 89. Thereafter, my lord, he approached the Honorable Labour Court.
Yes.
By way of filing reference 221 of 89.
Yes.
Lord, the Honorable Court ordered for restatement with full back wages.
Right.
That was on 1st of February 2000.
Correct.
No continuity, nothing, my lord. My lord, page 32. My understanding is wrong. Page 32.
Continuity will follow as a necessary corollary.
Yes, sir. But now what happens? Now what happens?
Statement.
Yes, my lord. Yes, my lord. That as 100% back wages are there, it should follow. But now, my lord, special civil application number 6017 of 2000 is preferred before the Honorable Division Bench by the District Panchayat. That is page number 89. That is the order of the learned single judge against the award, my lord.
Page 89.
89, my lord. 89, 89.
So what has this order to do with the present matter?
Yes, sir. Honorable learned single judge passed the back wages. Nothing about continuity. So he was to be reinstated. We have reinstated. I'll give the date, my lord.
What is the age? What is the age of the respondent in this matter?
My lord, he was born in the month of September 1966. My lord, he is eligible. He is entitled to 17th of October 88, but not on the basis of the continuity. I will say how. My lord, he is reinstated on 17th January 2006. So he is in service. He has to go 6 more years in service. My lord, today 14 years have passed. So he is entitled to 5 years benefit, fixed salary. 10 years benefit, that is by way of running pay scale. But his case is that continuity should be given, everything should be given.
Make some logical submission. The single judge only set aside the back wages. Everything else remained the same. How can you deny benefit of 17, 10, 88?
Then, my lord, there are judgments of our court. My lords have also issued notice, not only the other matter. Identical issue is there, but in this matter also.
We have issued notice in different matters, not this matter.
My lord, there are judgments of the division bench of our court that actual working is necessary. One has to actually complete 240 days in a year. That is firstly by learned single judge in special CA number 67 of 2012. 67 of 2012. So he is entitled, but he is not entitled for the interregnum period. I say that he is entitled for 86 to 89, as he has actually worked. He is entitled for other years, that is 2006 onwards. That means around, he has completed 20 years. No, this is the view taken by the learned single judge and division bench. I am taking my lord to that. It is actually a view taken by the division bench in number of judgments. I am taking my lord to that.
Mr. Mishra,
Lordship.
Which is that matter in which you have preferred civil application, which was there today? Item number?
That's what he was saying then.
Item number 11.
11.
In 11, there are some judgments.
In 11, your lordship has ex parte granted interim leave against the award.
11.
We are calling it for some other reason, not because of this.
11, there are up to 11. Now, do you accept this particular say of Mr. Munsha that you worked from 86 to 89 only?
No, 2006 onwards. Thereafter 2006 onwards. Your lordship may kindly see the page 32 of the award. Your lordship may kindly see.
Just tell us what is the finding given in the award.
The award is at page 32. The operative part of the award is that સામેવાળા અરજદાર 7/89 ના છૂટા કરવાનું કૃત ગેરકાયદેસર ગેરવ્યાજબી છે તેમ ઠરાવવામાં આવે છે. પેજ 32. અરજદાર
Some 3-4 judgments were there. Not this.
Lord, I have sent all the judgments through PDF. Lord, about 7 to 8 judgments to the court master.
Very well.
About 8 to 9 judgments. Lord, may I pray for one thing, my lord?
Just
Lord, even as one. Sorry.
Next week.
Next week. We will take up this matter in the next week on 4th November.
Lord, then may I, instead of that, may I make one request? Lord, as per my calculation as officer of the court, he is entitled. I started with that. Lord, we may grant benefits as per our calculation, and my lord may keep it after December or January, as soon as we are physically functioning. He will get the benefit. He is to get benefit. Not get anything. Lord, that is only, Lord, physical hearing is necessary. Lord, I will have to cite number of judgments. I will have to collect judgments from Mr. Mishra. Lord, I have already sent the judgment to PDF. Lord, he has 6 more years to go. May I address, my lord? Am I visible?
Yes, yes.
Yes, he has to work for 6 more years to go. he is going to get benefit as per I our have sent to calculation Mr. also. Muncha. Lord, he is I have disturbing sent me. it through PDF to Mr. Muncha. Lord, I am saying this. Lord, my learned
Okay,
friend.
have it next week. What is the problem, Mr. Munsha? Both of you can argue.
No, my Lord, I pray for. Otherwise, I have not prayed for it in all matters. This is the first matter wherein I am praying for that. Lord, number of judgments are there. Honorable Supreme Court also held so.
Get those judgments next week. What is the difficulty? We will hear you.
But this is a humble prayer, my Lord. I may not be misunderstood. Lord, I am saying that
Mr. Munsha, you are praying for what?
I am praying this wise, my Lord. I am praying this wise. Lord, actual benefit is to be given on the basis of number of working days per year. That is held by our court. It is held by the Honorable Supreme Court.
Mr. Munsha, we are aware of these settled principles of law. First thing, why should we go into all these issues when there is an award staring in our face?
Award is not award is for continuity. That is the Honorable Supreme Court says.
A poor man like this. Why do you?
No, with respect, Lord, he is getting everything. Honorable Supreme Court, allow me to read the judgment of the Honorable Supreme Court reported in 2000.
We will hear it on 4th.
My Lord, as on today, I am being paid minimum wage at 320 rupees per day after 20 years of service. But I am saying that he would get everything. I am saying that he is going to get everything as he has completed 13 years or 15 years of service as daily wager now. He is to get the benefits. Free statement. When the data free statement. But yes, but for the interaction period, not decide will
not be concluded. Let it be listed again on 4th of November 2020.
Now, I request for physical hearing. Lord, he is to get benefit. My Lord may say by way of interim. My Lord may say that after January or whenever we reopen, my Lord. No, my understanding is unnecessary taking time. I have already sent all the judgments which I am giving in advance. He has to pass over. He has to pass over the judgment. He has to pass over the judgments. Secondly, my Lord, I am making a statement. My Lord may direct that on the basis of the existing facts that he is in service right from 2006. Today we are in 2020. So he will get the benefit. My favor, page 32, your Lordship may kindly see. My learned friend is not bringing to your Lordship the correct fact before this honorable court. Lordship.
You talk
Lord, he is not allowing me to complete. I am saying only 1 minute your Lordship may kindly give. I will be able to point out.
That's all for today. It's time.
Lord, I pray that let it be after December or January. No, I have a serious objection. My learned friend is deliberately seeking. I say that meanwhile you would get the benefit.